in relation to the approval of the resolution plan, and it is expected that the order would be pronounced during the course of the day. In any event, in terms of the earlier order dated 27/1/22, this court is presently seized of the issue of whether the appellant would be entitled to claim set off during the arbitration proceedings, and that aspect would have to be considered independently.
Grateful.
Accordingly, adjourn the matter.
Very grateful one. Very, very grateful.
Based on,
Deeply grateful.
we'll take it up on a Wednesday only, so that
Yes, my lords.
once it is
Would your lordships consider having it sometime in November, my lords?
26th,
26th November.
26th.
Very grateful, my lords. Extremely grateful.
I'm appearing for the state lordship. I received the counter affidavit today. I'll be filing it during the course of the day, lordship. I'm requesting.
Sorry?
Still the counter affidavit today. I'll be filing it during the course
We'll
of the
be
day.
filing it during. What happened to the? It's been rejected.
Yes, lordship. That represent has been rejected. I'm
Third
placing.
council appearing for the state of Tamil Nadu states that the counter affidavit has been received and would be filed in the registry during the course of the day. Copy supplied to you.
No, my lord, not yet.
Copy thereof shall be supplied to the other side also to enable him to file his rejoinder thereto, if any. Earlier interim order of status quo shall stand extended till the next hearing. List on 3rd December.
Oblige.
Lord, the first matter is by the Road Transport Corporation.
Service is incomplete. Because now I think all these other matters seem to have been clubbed with this. So notice was issued and the
Lord,
service
in
is
the,
still
in the
awaited.
first matter, service is complete.
No, but once they're all clubbed together, Mr. Giri, we will hear all of them together. So you'll have to complete the process in all the
The other matters.
cases.
It's in the first
State
matter of
the
the search
petition.
is set to be complete.
The first matter,
service is incomplete in 27341.
the office report shows as in the first matter.
First
service
item,
is-
it seems to be
service is
complete. First item, it's complete.
First is complete.
Service is awaited in the third item,
The
perhaps.
matters.
Which one? 3074453, it's still awaited. This is the connected item.
Lord, the respondents would be the
That's
same.
item 23. 23, perhaps the service is still awaited.
Lord, if they have been served, they have entered appearance in the first matter, they could as well enter appearance, my lord, in the other
Are you
matters.
appearing for the
Parties are the
same
same.
parties? Same parties perhaps,
Parties are the same.
in all the matters.
It's a common judgment.
Millards, I'm a private.
Verify
Private
if-
entity, no, I'm only in one.
No,
Only
verify whether the same
Yes.
parties are there in the other items. If
We'll verify.
then you can
If we
enter.
are there, parents will take notice.
No. Office report dated. The 28/10/2025 reflects the status of service in this batch of matters. We find that some of the respondents are still not served or the proof of service is awaited. Learned counsel appearing for the respondents in SLPC number
Yes, Vinod.
26337 of 2025. Fairly undertakes to verify as to whether the same parties are added as respondents in the other matters, and if so, whether they would be filing, and if so, ascertain as to whether they would be filing, entering appearance on their behalf also. List on. Pleadings are in the first item, pleadings are
In the first,
complete.
first item, my friend has filed a counter.
You need to
State,
file
of course, my lord, is on the same side.
rejoinder or anything? No
The
rejoinder.
others, my lord, if if they want to file a
No,
counter, my
you
lord,
don't need to file a rejoinder to the account.
Lord, I don't think so.
Your choice. Pleading shall be completed in all the matters by the next date of hearing. Urgency, you have an
There's
order
also-
perhaps.
We have asked for an interim relief.
I see interim relief also notice was issued. List on 26th November.
As your lordship.
Milord, in this matter,
19,
I mentioned, Milord, one of the matter, Milord, Lordship ordered to tag. but it is not listed today.
Very-
Lordship, in yesterday, Madam Mohana mentioned this
Yes,
matter. for
we are
today.
adjourning the batch in any event. They might not have declared the results as well.
Yes,
Yes.
Lordship, may I have,
November first week is when they
Lordship,
expect.
kindly have it on Friday, Lordship, because it's the personal-
November first
Lordship,
week, they will declare the
Lordship,
results.
Lordship,
After that,
the
you have to
personal
do your homework
difficulty from my
to
part,
find
Lordship.
out whether any tainted
Lordship,
candidates have come through.
Lordship, the difficulty from my part is this is an AMA and all the applicants are here in Delhi, and accommodating accommodating them for like a long time here in Delhi is very difficult for me, Lordships.
Sorry,
All the applicants here in MA are here in Delhi.
why
have
are they in
traveled all-
Delhi?
just
We
they
never
have
asked them to
traffic
come.
also on the front of this. Lordships, may kindly have it on this.
They are
Friday,
the
Lordships.
tainted
Yes,
ones.
Lordships. Yes.
Are
they
you the untainted candidates or the tainted candidates?
Unattended candidates, Lordships.
You appeared for the exam.
Yes, yes,
Then
Lordships.
what is
No,
your
no,
urgency?
no, we don't appear for the exams. It's all attended candidates.
Then you are all tainted candidates.
Yes.
Tainted candidates have no role to play.
Lordships, may Madam Mohana know well known about this.
Whoever it is,
Maybe kindly have
tainted
it on Friday,
candidates, we are
Lordships.
not concerned with.
That's it.
Tainted candidates are out now.
Lordships on.
However
on
much you
Friday-
want to
on
bang
Friday,
your head
Lordships.
against the wall, we can't help you.
Lordships, kindly have it on Friday, Lordships.
Fine, if you can give the numbers, Lordship can dismiss those MS.
Lordships on Friday, Lordships.
Exams are over, everything over. What is it that
This
you
is the
still
one
want to achieve?
clarification they want in the para, Lordships. Maybe have it on Monday, Lordships.
No, no.
This is only for untainted candidates, my lord.
We are
Nothing
only
more than
keeping this matter alive to check whether any tainted candidates slip through the net and get appointment. Because that was the worry that was expressed by the untainted candidates who had appeared for the exam.
Yes.
Lordships,
That
very well,
the
Lordships.
matter was not being placed in
Lordships.
the public domain, so they don't know who is tainted, who is not tainted.
But the-
So now it's all come out.
And
It's
you
all
Now
come.
the difficulty
So-
is that Lordships.
We'll
Second or
pick
third
up in
week
the
of
second, third week of November.
Lordship,
Your lords,
Twenty-fourth November, is it? Very good.
Lordship, 17th November, the other day, Lordship.
No, not on a Monday, please. We'll take it up on a
Lordships.
Wednesday.
Yes.
Lordship,
Lordships,
Lordship,
if this
Lordships,
Monday,
Lordships,
Lordships, Madam
Lordships,
will file, Lordships.
Vivek Parya, we had moved an application for deletion of several pro forma parties, my lord. That application may be ordered.
Very well. What is your IA number?
202-957 of 2025.
202-957.
460.
Lordships, they all are attended candidates, Lordships.
So this is the lead SLP.
Very well.
And then category wise.
Application for- This application has been filed for deletion of the names of pro forma respondents. Full stop. At the sole risk and peril of the applicant.
Lordship, instead.
Yeah, please, Lordships.
The IA is ordered
First to argue.
permitting the deletion
It's already
of
expressed.
the names of the said respondents from the array of parties. Amended memo of party shall be filed within 2 weeks.
Grateful, Lordship.
The main matter,
Category wise.
letters for adjournment have been circulated.
Lord,
But
all connected matters to be listed together.
the learned council in some of the matters, don't mention everything, by the learned council for some of the matters in this batch. The cases are accordingly adjourned. List on 26th November.
Great.
My lord,
Much over.
these are all untainted candidate, my lord.
Budget published, my lord, that will be done.
That is,
Of the tainted people.
Tainted list.
Tainted.
Lordships,
tainted list has been put in the,
They're not giving because it's.
No, my lords have not passed any such.
Lord, our
guidance.
MS untainted, untainted MS, my lord. All MS are untainted, my lord. Kindly have a Monday.
no Monday, please.
Wana madam will, yesterday Wana madam.
We have already said tainted
Untainted, these
candidates.
all are
Untainted.
untainted.
You can't claim to be untainted if you've not been allowed to work till 31st December.
We are-
You have not been
we are-
allowed
we are
to sit for the
31st
exam.
December.
we are
We are,
working till
we are
31st December.
servicing.
You are in
Oh,
service
yes,
now.
we are
We are
working.
in service, my Lordships.
We all.
Then what is your worry then? Did you write the exam?
Para 47, we want.
Did
to
you
release
write the
verification.
exam?
Yes,
Did you write the test?
yes, yes,
You wrote the test.
yes, my lord.
So
But
the results will be
we-
declared.
We are non-joining candidates, my lord. Earlier we have appointment.
What
letters.
is your worry now?
Para 47, my lord, judgment,
What does
para
it re-
47, we want some clarification.
What clarification do you want?
Non-joining services candidates and joining services candidates, my lord, other departments. Only, my
So
lord.
you wish to go back to your old
Yes,
job?
yes, my lord.
Yes, my lord.
Kindly have.
Then
done
that's
that.
another case then.
Monday,
Some,
our case is totally different.
those who wish to go back to their old jobs have already applied by way of contempt proceedings. You are appearing in that.
My lord, only we
You are
want
appearing-
clarification, my lord. Kindly have a Monday.
If you have applied for returning to your old jobs, we've been told
No,
that
we
orders
want
in that
clarification.
regard
from my
will
lord.
be filed by November 10th. We don't need to clarify. The order is clear in that.
Kindly have a
regard.
Monday, my lord.
If you
Humble
wish to
request.
go back, they are bound to
Kindly
send
have a
you
my lord
back.
Monday.
No, 24.
This was issued on 1st August and made it returnable on 3rd. Therefore, there is an expectation a matter will come up again on Friday. But just may clarify that now that 26th
Matters need not be listed on 3110, even if a specific date has been given in any of the matters in this batch of cases, as they would necessarily have to be heard, together. And we are informed that the results of the selection tests held in, when did you hold the test?
September
7th and 15th.
7th and 14th
7th and 14th of October,
September.
September would be declared in the first week of November. Sorry,
The first week of.
not in the first week. We were told that it would be the first week.
But it's tentatively, it was the first week of November.
Would be declared tentatively in the first week of November. So list on, give the date.
My MS also, my lord. My MS.
All matters, we are not dismissing any MA today.
Grateful, Lord.
But rest assured, all tainted candidates are out. There's no more examination.
Your Lordship may.
Not just your claim, you need to be actually untainted. Not just your self-given label of being untainted.
Main judgment speaks, my lord, very clearly about.
We have not determined as to who is tainted, who is not tainted. That was already determined by the CBI, not by us.
That's in item number 20, Leonard SG leads as ballots. He is held up in court number 6 and ballots, it will take time. So I seek a short.
It's again
adjournment, my lord.
arbitration.
Yes, but it's a short adjournment, ballots only. seek.
One submission, of course.
Yes,
it's
Mr.
not approving
Tripathi.
anything. Lord, the award is of 20th of January 2020. The learned single judge, and I'm telling this as an officer of the court, my lord, did not modify the award, but severed what he thought was contrary to law and passed his section 34 on 10/2/21. As a result, I lost about rupees 1.09 crores from that award. It came down to 4 crore odd.
Yes.
The learned DB said that this is not severance, but this is modification and sustained the whole award. Now, their whole argument is that learned single judge has modified it, in which case, will not I get the whole award? If they are wrong and the learned single judge, my lord, has not modified it and only severed it, which is, I must tell your lordships as my lord's officer, my understanding also, Justice Bhakuru's judgment makes it clear, severed. And my lord, then I get 1 crore less. There can be no third option to this, my lord. I am okay with either of the two. Because my lord, I can't.
But have they paid you any of these
They
amounts?
have paid me. I have received not a penny. And my lord, they got 100% from the original employer, which was the Haryana Corporation. They had a right only to 2.5%. 97.5 was a pass through to me. They have paid me nothing. I have not got a penny. And from 2013, they are sitting on the money.
Ballots.
Therefore, my lord, I have no difficulty. Lordship may sustain the order of the DB, my lord, which they are challenging, in which case I get the whole award. Set aside the order of the DB, in which case.
But is there an agitation against the 34 order also?
Yes, ballots, we have ballots.
They filed an objection on 37. If your lordship just gives me 2 minutes, I'm not arguing it.
No, but they obviously want the entire award to be set aside.
Yes, ballots.
My lord, that's all right, but my lord, for that there is no answer that your lordships will see. It's a question, my lord, of their retaining monies which they had got. So it is, I can understand there's an answer on limitation.
With regard to the completion of the work, there's no dispute.
My lord, I have been given accolades. I have got completion. My lord, lordship knows in real estate matters, there is never a complete completion. Maximum one gets is what is called a partial. I got the full completion. I got accolades. I am the good boy who's paraded around saying he did it in time. And they are sitting on my 97.5%.
Ballots, it's not correct narration, ballots.
But
Leonard SG leads as.
If you receive the money from Haryana,
Ballots, we have.
State Roads and Bridge Development, is it? Haryana
Yeah, like
State Roads and Bridge Development
We
Corporation.
had received millets and we had already paid to them. They got adjustment of almost 90% of the amount millets. Respondent millets, they are making a wrong submission millets that they have got
You
nothing.
adjusted it.
Millets payment was made and a statutory and contractual adjustment total millets, it's 38.58 crores millets. They got it. They admitted. Only millets main case, 5 lakhs, 5
Which is
crores.
5 crores. They haven't paid me a penny out of it. There is no
It's only
dispute about
millets,
this 1 to
11%
15.
and odd millets will make submissions. Learned
Well,
SG
that's
millets
when they
leads
make
us
whatever
millets,
submission,
any
but-
sort date millets.
Well, the dispute.
The Solicitor General will always have
No millets,
matters
but
to
last date
attend
was
to.
here millets.
more politically sensitive ones. So arbitration may rank somewhere low on his priority.
But last date he was here millets.
4.5 crores.
Millets, last
So it
date
is
he
not
was
something
here
we
before
should
millets.
see.
Last date he was here millets. But matter could not be heard millets. Last date he was
Listen,
here.
I'm a
Any sort date millets.
contractor. I have succeeded. I've got accolades because that is why I said I'm okay with either sustaining the learned
The
single judge
division
or the
bench millets had
No,
not,
they want the entire award to go.
But then they have to show one ground. Let him say it, Milord. that
the
this is the
honorable
university.
division bench millets did not consider it on merit at all millets. He only said that modification is
No, but-
impermissible.
How
So-
do you bring it within the ambit of Gayatri Balasamy?
Show one ground.
Millets, learned SG will
Limited
argue.
grounds of challenge now.
Let's fill millets. We'll see.
Therefore, unless you're able to show us that the arbitrator did a faux pas somewhere on fundamental principle, the award will have to be
Millets,
sustained.
we will assume that that is the case exactly of
Let
that
him
millets.
articulate
Exactly
it. I
of
won't
that
even
millets.
oppose it. Let him articulate what is the perversity in the award. One perversity.
We will assume millets only honorable learned SG
I-
millets.
I-
He
I
is not
can't go
here.
beyond that. There's nothing. Other than I don't want.
Adjournment is sought on behalf of the learned Solicitor General, who is stated to be appearing for the appellant, for the petition. List on 12th November.
Much-
12th.
Much obliged.
They had deposited some amount in the High Court. Permit us to withdraw it.
Millets, this is millets totally contained. It has to go entirely. It was heard, then millets, it was passed millets. On the next date millets,
Arbitral Tribunal, section 13.
That amount at least is placed in a fixed deposit?
it is there millets.
There is a fixed deposit, there is an undertaking before this court that they will not enforce execution. And not what my learned friend will argue it out, and in fact, he did not travel beyond the division bench order.
But the learned
Not the
senior
chances
will
are-
maybe
Well,
right.
Hardships after
He is
hearing
available,
that-
he can argue.
No, no, I'm being led
He's a
by someone,
distinguished
Mr.
senior,
Not Mr. Tripathi knows the decorum.
No,
of the
I'm just-
court, So I would not like. to
I'm
press
just
that.
underscoring my desperation, my lord, on
Right.
behalf of my client.
So that's
Because they
the-
want
Well-
none of the money.
12th November.
Much.
Obliged.
Yes, Mr. Anand.
21, I am appearing on caveat for response was 1 to 6 months.
But I'm so sorry. Could it be a date? 12th, I'm not here.
I see 12th, you're not there.
11th, any other date.
12th is a Wednesday, so
There's some difficulty there. Any other date.
13?
Yes,
13,
yes.
13.
Obliged.
Proceedings arising out of the Atiyat Port Act. Now, my lords, under the Atiyat Port Act, my lords, there is a deputy collector who is the original authority. After that, there is an appellate authority who has comprehensive powers. Your lordship's judgments say that the powers are comprehensive and can go into any question. That appellate court's power is that of the additional collector. So that's already been exercised in my favor, against which there is a
In your favor, to what extent? By appointing you as a mutawalli.
appointing me as a mutawalli and
For-
every
Under the Atiyat Inquiries Act, there's no appointment of a mutawalli.
absolutely incorrect insofar as the facts of my case are concerned, and I'll point out how.
Under
Now,
the act shows which provision
No, no,
deals with the
it
appointment
isn't,
of a
it isn't.
mutawalli.
I'm not even concerned with that.
This
Question
is an Atiyat grant
Absolutely yes. Absolutely yes. Now,
and
mutawalli.
it's a work by user.
No, no, no.
There's no document,
Nothing about.
there's no
work.
document of creation of a work.
That is what I'm pointing out, that
No,
the,
is there a document?
because there isn't any. There isn't any
So
document
it's a
which
work
creates.
by
work.
user.
Not even a work by user. It is
Then-
a property which is given in the nature of, this is Inam land. Inam land will travel
So where
down.
is the question of bringing in a mutawalli at all?
I'll just point out. So the Sanad says it'll all be governed by the Sanad. So what does the Sanad says? The Sanad says, I am appointing you on 3 posts. The first post is that of a Pesh Imam, which is the person who's going to lead the prayers in the mosque. Second thing, with respect to the mosque is that I am appointing you also as the sermon giver or the khatib. The third thing is with respect to the mutawalli or the manager of the dargah. And all the
This
land,
is the initial grant.
initial grant which is here, the first
Show
document
us,
that
show us that document.
Please have that, my lords. Your lordships may have 74. This is the document of 1932 to 1933 in favor of my successor, my predecessor in interest, my grandfather. Please see. 74 minutes. The original document is on the left side. Hazrat so and so on the right side, top, your lordships will see 1932-33. I'll slowly read this. It is informed that Sayyid Shamsuddin, which is my grandfather, has been appointed as a mutawalli of Dargah so and so situated at village Udgir, Sharif, and as a khatib. Khatib Malos is a person addressing religious sermons, and the Pesha Imam leading the congregation to the mosque situated in the premises of the Dargah. It is informed that the said person will remain in service as a khatib and Pesha Imam, mosque and mutawalli to the Dargah permanently. No else can interfere or take part in the rendering of the services to the institutions by him. Service Inam lands for rendering the aforesaid service is entered in the table of succession statement, VDA number so and so, firstly 1332, etc. Lands are being granted to him to meet the expenses and rendering proper services to the institutions and for his own maintenance, and also for praying day and night before the Almighty God for long life and for maintenance of high
So
dignity.
there are multiple facets here.
Correct.
There is a grant, there is a separate appointment as a mutawalli for the Dargah. That does not mean that the mutawalli becomes the successor for the Inam lands.
Now, what has happened is
Therefore, you can't club both and say that mutawalli will now claim the succession under the original.
lordships are absolutely right. The dispute today,
That is the reason why the High Court says it should be.
That's a wrong dispute, and the wrong. It's been nomenclatured wrongly. Now the dispute
The
is this:
mutawalli is not the owner.
Mutawalli is only a manager.
He cannot claim
I am-
ownership.
Cannot
He
claim.
cannot claim rights of succession in
Cannot.
terms of
Cannot.
ownership.
He cannot. And I'm
That
not
is
saying
exactly what you're doing.
I'm not asking for that. That's my point. Please appreciate. I am saying so. That's the
The
confusion.
order of that assistant collector seems to give you that
Doesn't do
benefit.
that. Please see that. It doesn't do that. Please see. Now, if your lordships have
Possession of the land is to be given to you.
the possession of the land has to be given to the person who is the mutawalli and who is the successor in interest. So it's been given to me. Please see 171, the additional collector's order, and I'll take your lordships through that. And none of this has been discussed.
Who are these other people? They are
Well,
also
these
claiming under
people
the same
come- Just point.
grantee.
These people.
They are successors.
You are also.
I'll just point out. I'll point.
I'm sorry.
Our learned friend will just wait.
And you claim under a power of attorney,
No,
doctor.
no, but I'll explain everything. Just give me some time. My learned friend will just hold it.
The record before
These
the High
people have come up with a document which has been introduced for the first time in the rejoinder after the arguments have started in the High Court. I have taken specific grounds to that respect in the in my essay.
You have the Atiyat Inquiries Act with you.
Please have that. I'll just pass it on. What passed the time? Pass this on. Because this is in Telangana. Yes, we'll decide to know about council side. Well, let's. That finding at page 24, that finding at.
So let us see that assistant collector's order.
Please see that. Additional collector minutes. Now, 194. This is
Additional
the appellate court.
190.
194. It starts actually at, well, it's 171. The relevant part, the consideration starts at 194 onwards. And these are all my predecessors, my father, my grandfather, etc. Now, please see. Paragraph 1 on 194 minutes. Lordships have that. Having meticulously examined and perused the appeal from the appellant, the written
So
argument.
he is now appointing you as a mutawalli.
He is, because that is my application.
Is
before.
that part, is that a power that is conferred on him under the Atiyat Inquiries
Just
Act?
point out. Well, let's. Your lordships will appreciate, my lords. Allow me to answer that. The confusion which has been created by the deputy collector before the additional collector's order and which has traveled into the orders of the High Court is this, that under the Atiyat Inquiry Act, there is no power to appoint a mutawalli. Now, the law is this, that every right which flows from a sanat, will be decided by the Atiyat court itself. Comprehensive powers have been given to them. Just pass on that judgment. Well, let's please see this judgment of 1974 of this honorable court, which says that the power of the Atiyat court is comprehensive, can decide any rights. Please see this.
Not with regard to a waqf.
It is not a waqf. That's what I'm saying.
The dargah part of it is a waqf.
No, Manoj, please appreciate.
That is the reason why we said that this grant seems to be a composite grant.
Nobody is claiming that
Land is given, there is a dargah, there's a mutawalli appointment. Mutawalli appointment obviously could not be under the Atiyat Inquiries Act. It could not be in relation to the Atiyat. Atiyat is a grant. It's a gift. Arabic word, gift or present. Therefore, the dargah part of it is not part of the Atiyat.
Please see the sanad.
Therefore, if there are
The
two
dargah is
things
also the
there,
Atiyat. Dargah
and
is also
now
the Atiyat.
the worst part is you are claiming under a power of attorney.
I'll come to that. I'll come to that.
Where is the question
The
of
High
a
Court-
power of attorney being a basis for a claim of succession?
Yes. Because Mullah says that as a person on deathbed, a mutawalli on deathbed can do that. And that has not been considered. The additional collector.
Then you
Mullahs-
need to go before the competent authority who can appoint you as a mutawalli, not under the Atiyat Inquiries Act to be declared the successor of the Atiyat land.
I respond back to that, Manoj. I've heard what is falling from your lordships. Now, please, your lordships will allow me. Under the Atiyat Act, whatever has flown under the sanad, the grant, all of those rights which flow under the inam are liable to be tested by a
Now, in
Atiyat
any event, the matter is sent back to the Atiyat court to
please,
decide the
allow me,
applications regarding claims of
Allow me to
succession.
put it to your lordships, Manoj. There is a
Mr.
confusion which is
You
crept in.
go before the Atiyat court and
Lordships will hear me, my lords. I can respond back to the confusion that has been created by the High Court's order. I've
on
challenged
the
it.
face
So
of
just-
it, a power of attorney
A
holds.
number
Look
of
at
times-
section 7 of the Atiyat Inquiries Act.
Your lordships may just hear
Look
me.
at section 7, please. Does it entitle one successor to exclude the rest of them on the basis of a power of attorney?
Lordships may see.
Section 7 says succession to
99.
Atiyat grants shall, after the commencement of this act, be regulated by the personal law applicable to the last holder. The law applicable, Muslim law, does not confer the power of exclusion of successors on the basis of a power of attorney.
He's saying that.
That is exactly what you are trying to achieve.
Lordships may hear me, my lords. I've only been listening to your lordships. No, please hear me. The first thing is that, and so far as that instrument is concerned, that instrument is an instrument which can be created by a mutawalli on his deathbed. Now that is dealt with at page 199. Please see 199 for a moment.
Yes.
That's what my point is, my lords, that all of these factors have not been considered by the High Court. Now please see 199. At the foot of page 199, under 205 of lordships have that.
Look at the top. He is referring to section 32 of the Waqf Act. This is exactly the difficulty. That is why we are saying that this authority seems to be clubbing both acts and exercising powers under
I am
both.
sorry, my lords. I'm sorry. Where are you,
He
lords?
refers to section 32 of the Waqf Act.
He is setting that order aside. It is not his order.
It
He
is
saying-
not for him to set aside a Waqf authority's order.
Please see,
How does he exercise appellate power over the Waqf authority's order?
Please see. Allow me to just clear this. What is it that
You
that's been
seem
cleared?
to have been directed to go before the Waqf tribunal at some stage, which you never followed. That is also there?
Yeah,
You were asked to go before
First thing,
the
well, it's 199. Please
Waqf
see.
board and ask for relief?
Because I don't need to go to the Waqf board.
That's exactly why, because the
I don't need to go to
both
the Waqf
issues are
board.
clubbed together.
No, they have not.
And
been.
now the
They have
Atiyat
not been. With
authority
respect.
appoints you as a mutawalli.
With respect, it has not been done. Please see 199, where your lordships are pointing out to me that 32 has been relied upon by the Waqf, by the additional collector. Now, he is not relying upon 132. Allow me to read it. Please have 7 lines from the top on
You
199.
are the appellant in this?
Because I'm the appellant, my lords. The appellant filed an application
So
before.
you filed an application before the SDO.
This is my appeal. This is my appeal, which is being decided by the additional collector in my favor, against which they go in a revision. And today I'm before this honorable court. Now, please allow me 5 lines from the top and 199 with respect. The appellant filed an application before the SDO, Udgir on 21/9/96 and on 3/3/2011. In the decision dated 12/7/2013 in case number so-and-so, the SDO has recorded. So this is the finding of the SDO. That under section 32 of the Waqf Act, supervision and management of all waqfs in the state within the authority of the Waqf board under so-and-so, the power to appoint a mutawalli now vests with the Waqf board and not with this office. Therefore, the request of the applicant for appointment as mutawalli cannot be, in fact, as regards the inam lands, which are in dispute. Please see this. government directions are that such lands to be taken under government supervision be handed over to the Waqf Board for supervision and management of the board. Now, please see what follows from there. Under section, and he sets aside this order, 12/7/2013 on 201.
Which is
Please-
exactly what the High Court finds fault with.
Because the SDO is the officer under him. It is the deputy
That
collector.
doesn't mean that the SDO cannot be correct.
Please
We
appreciate.
restore trial court judgments and
Lordship,
set aside High
Lordship,
Court judgments
I'm
several times.
saying that this is
That doesn't
perversity.
mean that the
only
SDO
because
should
they could
always
not-
be wrong.
Lords,
Yes.
If your lordship see at page 201, paragraph at the top of 201, the second thing, the order number of 12/7/2013 of the
It may have
supplemental
been
officer
set aside, whether it
set
is
aside.
rightly
the
set
order.
aside is the issue.
Because this has been set aside because this was the order which I had challenged before the appellate court, which is this order that your lordships are reading. Now, please see. At
And
the
which
foot
they
of,
challenged before the High Court and succeeded.
and wrongly succeeded, 199 at the foot of the
They can
page.
say the same thing about your appellate
I can
order.
show that none of my documents have been considered by the High Court.
And on
I
what
can only
basis
show
are you
that-
entitled to claim under a power of attorney?
Now, please see. Yes, exactly that. Please see 199 at the foot of it, my lords.
Yes.
Under section 205 of the Muslim law, Mutawalli may select his successor at the time of his death. Now, this is permissible. This is the Muslim law, my lords. Likewise, under section 206, the office of
This is
Mutawalli.
again the same thing, clubbing two different things.
Lords, it is not.
Mutawalli is for the
I'll just
dargah.
clarify. I'll just-
You have no rights over the Atiyat grant merely because you're appointed as a Mutawalli. Whereas you get both now under this order.
Because under the Sanat, the dargah and the masjid were given
That
together.
doesn't mean that
There
they
were
should
lands
be
which were
held to be
there. We were-
compensated.
My lords,
They
under
are
one
covered by
document-
two separate enactments.
Because may I then, my lords, your lordships are clearly not with me. May I then, my lords, ask for one little thing and your lordships may just decide on that basis, my lords. One indulgence, my lords, the additional collector, which has to decide it once again, my lords, may do so expeditiously within a period of 6 months.
No,
Nothing.
we can't fix a time frame for that. You go before the Atiyat Court of Inquiry.
My lords, none of the observations will come in the, I've seen that, my lords. But my
Without
lords, the
getting
order is-
influenced by the observation.
Very well. I'll withdraw it then under
Very
the.
And having argued for some time, and senior counsel appearing for the petitioner seeks permission to withdraw the special leave petition, reserving liberty to the petitioner to also raise his claim before the Atiyat Court of Inquiry in terms of the liberty granted by the High Court in para 28 of the improved judgment and order. The special petition is accordingly dismissed with the liberty of his claim.
Very
He can also raise a claim, you also raise
Very
it.
good.
I'm like,
All grounds, all questions are left open, my lords.
I'm
That's
highly
already
grateful.
Very grateful, my lords.
Yes. Yes.
What is the issue which arises for your lordship's kind consideration? Let me summarize the issue, my lords, and then I'll
Yes.
briefly give the backgrounds to your lordships after.
Yes.
The issue is, my lords, in an execution proceeding which is pending,
Hmm.
and all that the order says is let the execution proceedings continue. In my execution proceedings against an order 21 rule 22 order, which your lordship knows as 2 years passes by, an application has to be moved for notice to the judgment debtor. They say let it continue and all rights and contentions are left open. And a chamber summon is also moved by them in my execution to say declare the award a nullity. Which the court says that how can in an execution proceeding by a chamber summon an IA in someone else's execution proceeding, I will declare it a nullity, is set aside. 2 LPAs come to be filed, which are not maintainable at all by a catena of your lordship's judgments. Those LPAs are kept pending for 3 years between 2015 and 18. And then in 2018, an order is passed, admitted subject to maintainability. And all execution proceedings are stayed without any reason, nothing, and maintainability is left open. And I have an award of 2010 in my favor of over $6 million, including estates, which I have not been able to realize. But now, my lords, in this background, let me give your lordships some factual issues which are important before your lordships comes to the legal point in issue. My lords, there was a dispute which arose between my father, his 2 brothers, and me. And the crux of the issue, my lords, was that there were businesses and estates, which really, and that is what the award ultimately holds, were really developed by me. And ultimately, there were differences because of my father's brothers, etc. And ultimately, my father and I went in for arbitration, just the two of us. We jointly appointed an arbitrator. After the arbitration commenced, my father wrote letters to the arbitrator. Of course, he's now sadly passed away. That's another issue. Wrote letters to the arbitrator saying that you are biased. I have no confidence in you. So the arbitrator said that then you take appropriate steps under Section 13 under the Arbitration Act on bias, etc., as is provided. No steps are taken, and the father stopped attending the arbitration proceedings.
This is under the 1940 Act.
This is under the 1996 Act.
Or 96.
Stopped attending the proceedings. The award comes in my favor of $6 million with certain estates, etc. The father writes to say that I will challenge this award. No 34 is ever filed. So this award attains finality, at least between me and my father. The uncles are not parties to this. Now, father in his will leaves the uncle as the executor. This gentleman, after 3 years of passing off the award, files a civil suit saying that the award should be declared a nullity. We naturally raise issues of maintainability. That suit is still pending and no steps to expedite it. That suit is still pending. We raise issues of maintainability. He asks for specifically by way of an application ad interim relief to stay the award. That is rejected by a specific order. In that, and I'll show to your lordships. No steps taken thereafter. When my execution is filed, he again, apart from the fact that the suit itself is clearly not maintainable in view of Section 5 and other provisions of the Act, how can you file a suit to declare an arbitration award as nullity? In my chamber, in my execution petition, he takes out chamber summons to say that declare that award as a nullity, which is of course one of the two orders.
By way of an objection under 47 or how
No,
exactly?
no, just chamber summons.
Just a chambers.
Now, Manoj, I'll deal with that issue also. If I'm sure my learned friend will get his chance. All the time respectfully submitting is that your lordships have time and again said that even as far as Order 47 is concerned, the executing court can look at all issues, including the issue of nullity, especially, but will never go behind the decree and look at the merits of the matter. Your lordships have heard in many matters arguments at length on that issue. We'll look at if it's a jurisdictional nullity. What the uncle is seeking to argue, the crux of his arguments is, apart from attacking the award on its merits, which it can't be done in an execution petition, and right or wrong, you have filed a suit which is pending, is seeking to say that, look, this award does not only concern or cover what is entitled to the son, that is me, or what belonged to his father, because only the father and son were party to the arbitration award. It is seeking to encroach upon properties owned by me. That is the uncle. This is his case. And the father did not participate in the proceedings. Now, my lords, father's not proceeding can never make a arbitration or jurisdictional nullity. If a party chooses not to appear, that and no 34th, so that award is attained finality. As far as your case is concerned, that this also covers my assets, that's another issue that the award has categorically dealt with, what has come to me, what is due to me. Your cases, some of these assets belongs to companies which you are a shareholder or are your asset. That's the nature of setup. The executing court, while issuing notice in the order 21 rule 22 for the proceedings to continue and rejecting his chamber summons to declare it a nullity, says that all issues, including whether some of these belong to you, will be decided in the execution proceedings. Naturally, it can't encroach upon something which is not part of the judgment debtors as estates, because I had filed IAs to say declare his estates, because he's the executor of the will. If he's the executor of the will, who will declare the assets? The assets can only be declared by the executor of what the judgment debtors' estates are. If something you show to the executing court is not belonging to the judgment debtor, is belonging to you, that is for you to show to the executing court when the stage comes. At the moment, let the proceedings at least commence. It is against these two orders that he comes. The LPA is admitted, subject to maintainability after 3 years, and all execution proceedings are stayed.
What happened though?
Please, my lords.
What happened in those appeals? There's no stay order here.
My lords, in those appeals, status quo is passed.
No, they've not been taken up till now.
No.
Hearing was expedited.
Yes.
The
And then status quo was passed here.
Oh, here also.
Yes, yes, yes.
Because the
No, but my lords, the more important and serious issue today is that, my lords, despite your lordship's repeated judgments,
2018.
despite your lordship's repeated judgments, that an LPA cannot lie, and the words used are will be enforced as if it's a decree of a court, doesn't make it a decree of the court under CPC. It's only an enabling provision to be executed like a decree, doesn't make it a decree. Thus, the question of LPA does not arise, because the words, whether in section 37 for domestic awards or under section 50 for international awards, the words used in section 37 are appeals from these and no other. So there is a specific exclusion, and the Supreme Court has said the act is a code in itself. If a particular kind of appeal is not mentioned, that is also deemed to be rejected, deemed to be excluded from there. And there are, as I said, any number of judgments on the point, including judgments of the Bombay High Court, which are ignored on the point. Now, my lords, our respectful point is that the merits is not what even your lordship should be troubled with, because that is an issue which will be argued before the executing court at all. And there also the executing court will not go behind the decree. The issue that the executing court will look into is that while I am executing the award, for instance, attachment orders are being passed. Am I passing attachment orders against assets which don't belong to the judgment debtor but belong to the person concerned? That I can understand. Since then, the uncle has also passed away and his son has come on, his legal heir has come on record. As far as that is concerned, that's only a factual part of the narration. The issue which comes up for your lordship's kind consideration is that if the court concerned leaves all issues, including your rights, to estates open, to be dealt with at the right stage, A, what is your grievance? In any case, the executing court at the appropriate stage will decide. But I argue against myself that suppose the executing court had not given this liberty. That's the highest can be said, that no order was passed protecting your rights. Even then an LPA can't lie. Your remedy can't be an LPA because you are aggrieved by any order of the executing court. The LPA is not the remedy. It may be the worst order, but the LPA is not the remedy. But here your interests are protected. And I tell you also what the background to it was. There was a general corpus. And the award notes it in detail that really these businesses grew because of the son. They ultimately said that, look, there were family settlements, you disregarded family settlements, etc. We are now awarding $6 million to the son, and he had a 70% share in the corpus. And as far as other estates are concerned, where you also have parts, we are debiting the amount that he is entitled to from his claim to be adjusted against you, and then the estates come to you in consideration. So that is, of course, the merits will be dealt with by the appropriate court, but there's a reason to what is said there. Their argument has been, no, you're trying to enforce also estates and assets which belong to me. Now, my lord, surely, A, the executing court leaves it open. I'll show those orders to your lordships. B, even if it had not left it open, The fact remains is LPA is not the remedy. Thirdly, my lords, after 3 years of pendency of the LPA, the two LPAs, you admitted saying subject to maintainability and execution proceedings are stayed. The reason that your lordships passed the status quo order, it is important for your lordships to know that, because we argued on that day that now today I can't proceed with my execution. I can't ask for attachment. I can't ask for interim orders if this man fritters away the assets. Where will I go? What will I execute? It is in that context that this court passed the status quo order, which was passed on that day. So today, my lords, let me show to your lordships the relevant statutory provisions.
Yes.
And the judgments on the point to make good my point that an LPA could not lie. And if an LPA could not lie, that's the end of the matter. Rest is not an issue. What you can raise before the executing court is another issue. Now, there the court has still left it open. There also, my lords, if it were to be argued, I would argue before the executing court that you can't go behind the decree on merits and sit in appeal over an award. You will purely have to make a case of jurisdictional nullity, which is within very strict confines of what jurisdictional nullity is, and make out a case there. In any case, the executing court has said that all questions of whose assets they are will be dealt with when the time comes and I'm passing appropriate orders on the issue. So, my lords, given this provision, please have the statutory scheme and then the judgments, and then I'll come to the concerned orders.
Yeah. I'm perfectly willing that the appeal court decide the issue of the maintainability of the LK. That is really the burden of this all. And
Now the matter is pending before us. It's been pending for so long. We might as well decide the issue instead of again asking the High Court to decide.
How could the court admit and say we'll leave maintainability open after 3 years?
There's no point in again turning back the clock and sending it back to.
all these issues were raised. There are many more things which
In 2018.
That's correct. And my lord, then they said that let this issue of maintainability, because that's the issue taken.
Now we'll hear it.
I don't know, but the High Court has said that is wrong with. It hurts, and there are many other facets to the matter which I'm not.
After keeping the matter pending for 3 years, saying that we are admitting it subject to maintainability is neither here nor there. Yes.
These have Section 5 of the Arbitration and Conciliation Act.
Yes.
Extent of judicial intervention. My Lord Justice.
Yes.
Section
3G. Yes.
Extent of judicial intervention. Notwithstanding anything contained in any other law for the time being in force, in matters governed by this part, no judicial authority shall intervene except where so provided in this part. So, my lords, Section 5 bars any judicial intervention with an arbitration proceeding or an award until and unless it is provided under the Act itself. So
Yes.
barely, because when I come to 34 and 36, it says will be enforced as if it is an appeal. Doesn't mean the civil procedure court starts applying and it becomes a decree and thus an NPA lies. That's the question being sought to be argued from the other side. That because as if it's a decree of the court means it's a decree. And that is why CPC applies. And if CPC applies, it's a matter of moment. And thus in the light of Babulal, Khimju, etc., LPA will lie. That's the line of argument sought to be raised. Now, my lords, kindly have Section 34. Okay. Ah. Four. My lord, sorry, I need to show one more section. Section 13 for a minute, my lords. Challenge procedure. And want me to say 3 and 4? Or 5 also. Section,
Yes.
section 13, subclause 3, 4, and 5. Unless arbitrator challenge, unless the arbitrator,
Perhaps two also would be.
just a minute, 2 also, my lords. Subject to subsection 4, the parties are free to agree on a procedure for challenging an arbitrator. 2, failing in any agreement referred to in subsection 1, a party which intends to challenge the arbitrator shall, within 15 days after becoming aware of the constitution of the arbitral tribunal, or after becoming aware of any circumstances referred to in subsection 3 of section 12, send a written statement of the reasons for the challenge to the arbitral tribunal. 3, unless the arbitrator challenged under subsection 2 withdraws from his office, or the other party agrees to the challenge, the arbitral tribunal shall decide on the challenge. 4, if a challenge under any procedure agreed upon by the parties or under the procedure under 2 is not successful, the arbitral tribunal shall continue the arbitral proceedings and make an arbitral award. So, Malas, that's exactly what the arbitral tribunal did. Father complained, then made no application under 13, and then later after the award said, I will challenge it. That's the only relevance of that, not really to the issue. Now, please have section 34. Section 34.
Yes.
Application for setting aside the arbitral award. 1. Recourse to a court against an arbitral award may be made only by an application for setting aside such award in accordance with subsection 2 and subsection 3. And then subsection 3, my lords. An application for setting aside may not be made after 3 months have elapsed from the date on which the party making that application had received the arbitral award, or if a request has been made under 33 from the date on which the request has been disposed of by the arbitral tribunal, provided that if it is satisfied that the application was prevented by sufficient cause from making application within the said period of 3 months, it may application within a further period of 30 days. Now kindly have, my lords, 36. My lords have
Yes.
36.
Yes.
Enforcement. Where the time for making an application to set aside the arbitral award under section 34 has expired, then subject to the provisions of subsection 2, such award shall be enforced in accordance with the provisions of the Code of Civil Procedure in the manner as if it were a decree of the court. This is what my lords and lords have repeatedly interpreted. Then subsection 2. Where an application to set aside an arbitral award has been filed in the court under 34, the filing of such an award application shall not by itself render that award unenforceable.
My lords,
Full court meeting today.
Lordship, one mentioning Lordship, item number 19, Lordship. Our matter is also with tag, previous order was tag, Lordship. Matter, our item number.
Does not come?
Lordship.
Has it come today in the list?
No, that's why I mentioned my senior Nand Kumar, mentioned first morning, Lordship.
Give your number.
Already given the appearance also, and court master accepted. Court master is saying your name.
Let-
is not-
If your matter is not listed, how will your appearance be recorded?
Why the matter has not been listed? That is the issue. It is the tag matter.
That doesn't
Order
mean
not-
that your appearance will be noted when your matter is not listed comes.
It is the tag matter previously, Lordship.
It has not come, take it up with the
Give
registry
the
as to why it has not been listed.
Why the matter has not been listed?
Take it up with the registry. We are not here to account to you as to why the registry has not.
Matter
Yes,
is
Mr.
the
Cole.
connected matter. Why the
mentioning item 106, an adjournment letter has.
Wait till the matter reaches. Yes. In the High Courts, Mr. Kaul, Senior Counsel hold a lecture series for the guidance of youngsters in the profession. Perhaps that is very much needed in the Supreme Court. Very, very much needed. Because we have a motley crowd from across the country here with absolutely no guidance. Unfortunately, very few first principles, mostly no fundamentals. And everyone wants to, they see big bucks here. That is the only difficulty. They need to lay the foundation for the big bucks to come. That doesn't seem to be a part of the concern. Just being here for sufficient time seems to send out the signal that you'll make the big bucks automatically. Perhaps that unfortunate situation may also come to pass, but hopefully I'll be gone by then. Yes.
My lords, I think to some extent, even the senior members of the bar can't shy away from the responsibility that they're also responsible for this increasing practice and belief that all that matters is big bucks. The means are not important.
It doesn't really
What is important?
matter.
I must confess, we can't shy away from our share of faults also. Of course, the youngsters do need guidance. We are also to be blamed for it, my lords. It's,
So be it.
yes, my lords,
Yes.
would your lordships be kind enough to have section 36, which I was
Yes.
reading to your
36.
lordships?
Yes.
I was on subsection 2, my lords.
2.
Where an application to set aside the arbitral award has been filed in the court under section 34, the filing of such an application shall not by itself render that award unenforceable unless the court grants an order of stay of the operation of the said arbitral award in accordance with the provisions of subsection 3 on a separate application made under for that purpose. So my lords, clearly 34 is the challenge. 36, if you need a stay, and as your lordships are well aware, if this were to be read with the para just above the explanation, that stay application also has to be made while the 34 is pending, not after the 34 is over. But please have 35 also, my lords, finality of arbitral awards.
Yes.
Subject to this part, an arbitral award shall be final and binding on the parties and persons claiming under them respectively. So clearly between the father and son, it has attained finality.
Yes.
And any legal heir of the father. Then my lords have section 37.
Yes.
Notwithstanding anything contained in any other law for the time being in force, an appeal shall lie from the following orders and from no other to the court. So my lords, two things: non-obstante clause and no other specific mandate of the statute. Your lordships have said in judgments, even if the word no others was there, the fact that it is not mentioned itself is taken as a exclusion, because then the Commercial Courts Act came to be interpreted in that light.
Right.
Now please have section 50 after that. And sorry, and subsection 3 also of section 37.
Yes.
No second appeal shall lie from an order passed in appeal under this section, but nothing in this section shall affect or take away any right to appeal to the Supreme Court. Then section 50, appealable orders. Notwithstanding anything contained in any other law for the time being in force, the appeal shall lie from the order refusing to, and those are given. Now, let's just keep two things in mind. Even section 50 has come to be interpreted by this court. Though the words "and from no other" is not used there,
Yes.
and it pertains to international part 2 arbitrations, the court has said clearly in LPA, even against the section 50 will not lie. Without the words "no other" there.
Right.
The very fact it's not mentioned, no LPA will lie against it. Then my lords would be kind enough to have the Civil Procedure Code, section 47.
Page 30. Yes.
Section 47. Questions to be determined by the court executing decree. All questions arising between the parties to the suit in which the decree was passed or their representatives and relating to the execution, discharge, or satisfaction of the decree shall be determined by the court executing the decree and not by a separate suit. Then 3. Where a question arises as to whether any person is or is not the representative, such question shall be, for the purposes of this section, shall be determined by the court. Now, my lords, your lordships, in repeated judgments, including Breakwell, Vasudev, and then Electrosteel, your lordships were that day referring to when we had mentioned the matter, have said that whether a decree is erroneous on law or facts, is wrong on merits, is not for the executing court to go into. Section 47 can't be interpreted to mean you'll go behind the decree. And the words used in Electrosteel are, is limited only to the issue of voidness or nullity of nullity because of lack of jurisdiction. That is only a limiting scope that 47 is to be interpreted. Doesn't mean that you will get into the whole merits of the matter. Now, my lords, Electrosteel, if your lordships will recollect, why was 47 entertained there? Because there was an MSME award which came after.
There was no 34 in that case.
There was no 34, and also equally importantly, your lordships are, what is important is more than that. My lord, what is important is, in Electrosteel, the award came after, under the IBC, the claim had been extinguished. So the court said that if a claim is extinguished, how can you pass an award on the asking of the creditor, because he has no right to pursue an arbitration? And that is why it is a nullity. And because it is a nullity, section 47 will apply. It is not as if in an arbitration petition, ordinarily a 47 will lie and orders will be passed. So there were peculiar facts to the case. I'll just come to them because I'll distinguish those 2-3 judgments. So broadly, the facts were that you have an IBC proceeding extinguishing a claim completely. Now, if a claim is extinguished, how do you pursue it further? That's why, my lords, in the matter out of context, which I was arguing in the morning, I was not on the claim being pursued in the arbitration. I was only limiting it to set-offs in that case. So if there is no claim in the eyes of law, then where is the jurisdiction of the arbitrator? After all, there has to be an arbitrable claim for the arbitrator to exercise his jurisdiction. If there is no arbitrable claim, what does the arbitrator exercise his jurisdiction over? And that is why the court exercised section 47, not to go into merits of the matter, not to go into, in fact, my lords, in your lordship's words in Vasudev were, I'll give the citation, but the words are, a court executing a decree cannot go behind the decree. Between the parties or their representatives, it must take the decree according to its tenor and cannot entertain any objection that the decree was incorrect in law or facts. and only limited ground between electrosteel and both breakwell is of voidness or nullity because of lack of jurisdiction. That is the only ground. Now, surely, firstly, that doesn't exist. Now, even if it exists, you'll take it in the execution proceedings. And I just come to those provisions because at the stage we are still at. Please now have, my lords, after this, Order 21, Rule 22. Take it from there. My lords have Order 21, Rule 22
287.
of the CPC.
Yes. Yes.
Notice to show cause against execution in certain cases. Where an application for execution is made more than 2 years after the date of the decree or against legal represent. That's why we went by an Order 21, Rule 22. It is this order which has been only passed saying that proceed with the execution. It's not that attachment orders have been passed, and I'll show that order. And now please have Order 21, Rule 23. My lord says that. Order 21, Rule 23, wherein the person to whom notice is issued under Rule 22 does not appear or does not show cause to the satisfaction of the court why the decree should not be executed, the court shall order the decree to be executed. 2. Where such person offers any objection to the execution of the decree, the court shall consider such objection and make order as it thinks fit. So when you reach this stage, you will find your objection as to nullity of the award. You will find. Now you have to make out a case if there's a nullity or not. If there is none, the court will pass an order accordingly in the matter. But we are at the stage of chamber summons under Order 21, Rule 22, where the court says you can proceed with the execution. But more importantly, my lords, even at that stage, we filed Order 21, Rule 22, and we were worried that they are frittering away assets. So we said, please, we filed an IA under Order 21, Rule 41 for declaration and disclosure of assets. So in that, they filed an affidavit. In that, they filed an affidavit to say even my properties are included. The court, both in Order 21, Rule 22 chamber summons moved by us, and in the chamber summon moved by them declaring an award a nullity in my execution proceeding, said that the issue of attachment, the issue of property whom it belongs to will be decided at the appropriate stage. At this stage, it is proceeding with the execution. What you have practically done with the order is you have strangled and suffocated the entire execution proceeding today. I can't proceed with the matter. This impugned order, apart from there being no maintainability to the LPA, effectively brings the execution proceedings to a halt. And my lords, your lodges have repeatedly said in arbitration matters that as far as possible, it should be expeditious. Look at the signal we are sending. You file an LPA which is not maintainable, then you take 3 years and an order comes to be passed, admitted subject to maintainability. And I, with an order of 2010, am still not a penny has come into my pocket as far as that award. And that award between at least me and my father has attained finality. Now, when I execute it and you think it's your property, not your brother's, we'll see it at that stage. But you can't strangle the entire execution proceedings at this stage. Then, my lords, now kindly have some of the judgments on the point on why an LPA cannot lie. And then I intend showing your lodges just the 2 orders in the chamber summons and the impugned order which was passed. Would your lodges be first kind enough to have give a compilation? We'll start with Tuesday Lawson. हमने पेज नहीं दिया compilation का यहाँ. Please give one to the other side also. Whereas I'll only, the judgments, I'll only take your lodges to 2 or 3 crucial judgments on the point. The first judgment, my lords, is, which is page 1.
Yes.
Paramjeet Singh Pateja Lodges need not bother. I'll just tell you, Lodges, the proposition, and I leave it at that. I'll only read the relevant.
Tell us the paragraph number.
Yes, my lords. The relevant paragraphs for this judgment are para 21, 20, 21, 28, 29, 42. Before that, 37, 42, and 43, Roman 4 and Roman 5.
Very good.
Effectively, my lords, the issue in this was that under the Insolvency Act of 1920, if you had a decree in your favor, you could give an insolvency notice under Section 9(2) of the Insolvency Act 1920. In this matter, it was an award, not a decree. So the question which came up was that even if you have an award, can you give an insolvency notice under Section 9 subclause 2 of the Insolvency Act 1920? The court said it is not intended to make it a decree for all purposes. It is only a decree for purposes of enforcement, not for all purposes. That is the relevance of this judgment. Now, my lords, the second judgment which I'll request your lordships to go through with me is Fuesday Lawson versus Jindal Exports. Page 27, my lords.
Which paras of this?
Yes, my lords. We'll start from one. You give them the, I'll read that. You give them one. Yes, my lords, I'm just giving the, yes. My lords, the relevant paras are para 1, 3, 36, subpara Roman 7, 74, 89 to 91.
74, 89 to
91.
91.
Now, this, my lords, was under Section 50 of the Arbitration Act, which relates to 1996, which relates to Part 2. But as I showed to your lordships, 50, if at all, is still a bit more liberal than 37, although the same principle is applied here. Now, please see, my lords, para 1, leave granted, so and so. The common question that arises for consideration by the court in this batch of cases is whether an order, though not appealable under Section 50 of the Arbitration and Conciliation Act 1996, hereinafter referred the 1996 Act, would nevertheless be subject to appeal under the relevant provisions of the letter patents of the High Court. In other words, even though the Arbitration Act does not envisage or permit an appeal from the order, the party aggrieved by it can still have his way bypassing the act and taking recourse to another jurisdiction. Now, my lords, kindly have paragraph 3. A correct answer to both the questions would depend upon how the 1996 Act is to be viewed. Do the provisions of the 1996 Act constitute a complete code for matters arising out of an arbitration proceeding, the making of the award, and the enforcement of the award? If the answer to the question is in the affirmative, then obviously all other jurisdictions, including the letters patent jurisdiction of the High Court, would stand excluded. But in the case the answer is in the negative, then of course the contention of Mr. So-and-so must be accepted. And kindly have para 36 on page 43.
Yes.
Please have 36 subclause 7 on page 44.
Yes.
The exception to the aforementioned rule is where the special act sets out a self-contained code, and in that event, the applicability of the general law procedure would be impliedly excluded. The express provisions need not refer to or use the words letter patent. But if on a reading of the provision, it is clear that all further appeals are barred, then even letters patent appeal would be barred. And now kindly have, my lords, paragraph 89 on page 65.
Yes.
It is thus to be seen that the Arbitration Act 1940, from its inception and right through to 2004, in P.S. Satappan, was held to be a self-contained code. Now, if the Arbitration Act 1940 was held to be a self-contained code, on matters pertaining to arbitration, the Arbitration and Conciliation Act 1996, which consolidates, amends, and designs the law relating to arbitrations, brings it as much as possible in harmony with the UNCITRAL model, must be held only to be more so. Once it is held that the Arbitration Act is a self-contained code and exhaustive, then it must be held using the lucid expression of so-and-so that it carries with it a negative import, that only such acts as are mentioned in the act are permissible to be done, and acts or things not mentioned therein are not permissible to be done. In other words, a letter patents appeal would be excluded by the application of one of the general principles, that where the special act sets out a self-contained code, the applicability of the general law procedure would be impliedly excluded. We thus arrive at the conclusion regarding the exclusion of a letter patents appeal in two different ways. One, so to say, on a micro basis by examining the scheme devised by Section 49 and 50 of the 1996 Act and the radical change that it brings about in the earlier provision of appeal under Section 6 of the 1961 Act, and the other on a macro basis by taking into account the nature and character of the 1996 Act as a self-contained and exhaustive code in itself. In the light of the discussions made above, it must be held that no letters patent appeal shall lie against an order which is not appealable under Section 50 of the Arbitration and Conciliation. Now, my lords, what is not appealable under 50 can't be appealable under Section 37, my lords. Now, please have, after this, the next judgments, and this, my lords, would be of some assistance to your lordships, although it's a Bombay High Court judgment, in the Jet Airways matter on page 74. Kindly have para 16 on page 97.
Yes.
Justice Haran, para 16.
Yes.
On page 97. Apart from the above binding precedent, even on an independent consideration of the provisions of the 1940 Act and the 1996 Act, the conclusion is inevitable that proceedings under 36 are not proceedings under the code. As noted above, the Arbitration Act 1940 amended Section 104 of the Code and subclause A to F of subsection 1 of Section 104 of the Code, which all dealt with arbitration proceedings, were deleted. The legislative intent was thus very clear, and precisely for this reason, the legislative intent would be clear, namely that arbitration proceedings and all proceedings arising therefrom will be governed only by the Arbitration 1940, which has been repealed and replaced by the 1996 Act. The Supreme Court has already interpreted the words as if it was a decree of the court, which clearly shows that only the procedure for enforcement of a decree passed by the civil court is to be utilized for enforcement of an award, and merely on that ground the said proceeding do not become proceedings under the code. In our opinion, they continue to be proceedings under the 1996 Act. In fact, Section 19 of the 1996 Act also makes it clear that the provisions of the code do not apply to the arbitration proceedings. This is a departure from the 1940 Act, in as much as under 41 of the said Act, it was provided that subject to the provisions of the 1940 Act, the provisions of the code shall apply to all proceedings before the court under that Act and to all appeals under that Act. Such provisions is completely absent in the 1996 Act, and this is one more indication that proceedings under 96 Act, even for implementation of the award, cannot be considered to be proceedings under the code. Even Section 41 of the 1940 Act has been construed by the Supreme Court in the cases of Union of India versus Mohinder Supply and West Bengal versus Gaurang Lal Chatterjee, and it is held that the said provisions and subject to the limitation contained in Section 39 of the 1940 Act, for all the aforesaid reasons, we have no hesitation in holding that nature of proceedings under and before of proceedings before the learned single judge or proceedings under the 1996 Act and not proceedings under the code. Another way of looking at this aspect is the question as to what would be the effect of holding that a letters patent appeal is maintainable in juxtaposition to the scheme of the 1996 Act. Under Section 2E of the 1996 Act, the term court is defined, which we have already extracted here and above. Thus, in Mumbai, the High Court the High Court is the court which is the principal civil court of original jurisdiction for the geographical area of Greater Mumbai, which consists of two districts, namely Mumbai and Mumbai suburban. In other districts, by virtue of the definition of the term principal civil court of original jurisdiction given in the Bombay Civil Code, the respective district courts would be courts under Section 2E of the 1996 Act. In fact, this controversy has now settled by the full bench judgment of this court. Thus, if we hold that the latest patent appeal is maintainable when an order in proceedings under Section 36 of the 96 Act is passed by a single judge of the High Court, a latest patent appeal will lie to the division bench, whereas if an order is passed by the district court outside Mumbai and Mumbai suburban district, no appeal would be maintainable either under 96 Act or under the code, even if one accepts the contention of the learned advocate for both the parties that proceedings for implementation of the award are not proceedings under the 1996 Act, but are proceedings under the code. If the aforesaid interpretation is accepted, it would lead to a piquant situation where if an order in proceedings under 36 is passed by a single judge of the High Court, the same will become appealable, whereas an order passed by the judge of the district court will not be appealable. With a view to avoid such startling result, it would be safe and prudent to interpret the provisions of Section 36 of the 96 Act in such manner as to hold that said proceedings are not proceedings under the code, but the same are proceedings under the 96 Act. Now kindly have para 19 to 22. Please have 22 on page 100. In 22. In fact, a perusal of the 1996 Act and the 1940 Act will indicate that both the enactments provide for filing of an appeal only against some specified orders and do not provide an appeal against every order passed in the proceedings under 96 Act. It is well established that the general law cannot defeat a provision of special law to the extent to which they are in conflict. Else effort has to be made on reconciling the two provisions by homogeneous reading. In the present case, the provisions of Section 37, the relevant portion of which is paramateria, leave no manner of doubt that the provisions of the special enactment will prevail over the general law, namely the 1908 Code. The statutory scheme of the 96 Act and the letter patent and binding precedents of the Supreme Court and this code lead us to only one conclusion, that clause 15 of the letter patents are impliedly excluded by the 1996 Act. And kindly 30, no. And now have, my lords, the judgment of the Supreme Court in simplex, which is on page 67 and then 12. Okay.
Yes.
My lords have
Yes.
page 67, para 1. The short question that arises for consideration in this appeal is whether an intra-court letter patents appeal under clause 15 of the letter patents of the High Court of Calcutta can be maintained against an order passed by the single judge on an application for condonation of delay filed along with the petition for setting aside an arbitration award under Section 34 of the Arbitration and Conciliation Act, hereinafter referred to as the Act. And kindly then have para 12 on page 72. The Act as applicable in the present case provides for a remedy of appeal in terms of Section 37 of the Act. The same reads thus, my lord, that I have already read. And kindly have the para below it after the provision. On a bare reading of this provision, it is noticed that the remedy of appeal has been provided only against an order of setting aside or refusing to set aside an arbitral award under 34. No appeal is provided against an order passed by the court of competent jurisdiction condoning delay in filing the petition under Section 34 of the Act as such. The division bench in the impugned judgment therefore rightly noted that the remedy of appeal against the impugned order of the learned single judge was not otherwise available under Section 37 of the Act. And then kindly have, my lords, para 13. In our opinion, the issue is squarely answered against the respondent by the decision of this court in Fuesday Lawson. In that judgment of the learned single judge dated so-and-so was passed on an application purported to be under 34(3) of the Act for condoning delay in filing of the petition for setting aside the arbitral award. Hence, the remedy of letters patents against the decision is unavailable. The question as to whether the learned single judge had rightly exercised the discretion or otherwise could be assailed by the respondent before this court by way of special leave petition, but certainly not by way of a letter patents appeal under clause 15. So my lords, the issue is not against what the appeal comes. In some matters, it has been against condonation of delay. In some other case, under some other provision, the question is if the appeal is not provided for. So you can't distinguish these judgments by saying, oh, this related to delay, this relates to execution. That's not the question. The question is either an appeal is provided or is not provided. If it's a self-contained court, it has to be strictly interpreted, and all other appeals which are even not mentioned there stand excluded impliedly. Then, my lords, your lordships may kindly have the Khandla, agree. Khandla Export Corporation on page 169. This. My lords, the paragraphs in question are, I'll just read one paragraph, but the crucial paras are 20, 21, 25, and 27. And kindly just have para 27 on page 187.
Yes.
The matter can be looked at from a slightly different angle. Given the object of both the statutes, it is clear that arbitration itself is meant to be a speedy resolution of disputes between parties. Equally, enforcement of foreign awards should take place as soon as possible if India is to remain as an equal partner, commercially speaking, in the international community. In point of fact, there is a for enactment of Commercial Courts Act is that commercial disputes involving high amounts of money should be speedily decided. Given the objects of both enactments, if we were to provide an additional appeal when Section 50 does away with an appeal so as to speedily enforce foreign award, we would be turning the Arbitration Act and the Commercial Court Act on their heads. Admittedly, if the amount contained in a foreign award to be enforced in India were less than ₹1 crore and a single judge of a high court were to enforce such award, no appeal would lie, in keeping with the object of speedy enforcement of foreign awards. However, if in the same fact circumstances a foreign award to be for ₹1 crore or more, if the appellant are correct, enforcement of such award would be further delayed by providing an appeal under so-and-so of the Commercial Court Act. Any such interpretation would lead to absurdity and would be directly contrary to the objects sought to be achieved by the Commercial Courts Act, speedy resolution of disputes of a commercial nature involving so-and-so. So, my lords, the effect is, whether it is Section 50, whether it is the Commercial Courts Act, speedy resolution and enforcement has been held to be the object. And they say if you have this kind of a mechanism of appeals, you literally turn every such act on its head. And then, my lords, no, that's not necessary. My lords, another judgment on page 203 is Sundaram Finance. Only para 14 and 19. And I'll tell your lordships, without troubling your lordships with the judgment, broadly the issue was that if an award is passed, should I first present it to the court which passed the award and a decree, and then it's transferred to another court to enforce the award? Because in a decree, you have to transfer it to the court concerned, which has jurisdiction over the assets. The court said no. It may be as if it were a decree of a court, is not a decree. The award can be presented anywhere. You seek the asset and you go there and present the award. You don't have to go to the court under whose jurisdiction the award was passed. That is what Sundaram Finance is. Now, my lords, very briefly, let me just show these two, Breakwell and we have Breakwell in this. Breakwell and Vasudev, my lords. You have electrosteel also? Okay. Breakwell, 434 is Breakwell. Page 434 is Breakwell. 434. Well, let's kindly have 434 Breakwell, only para 23. My lords have para 23 on page 442. What's that? Huh?
Para 23.
Sorry, my lords, I need to read para 20 also. 20 and 23. Para 20 on page 441.
Yes. Yes.
It is no longer res integra. Sorry.
441.
It is no longer res integra that an executing court can neither travel behind the decree nor sit and appeal over the same or pass any order jeopardizing the rights of parties thereunder. It is only in the limited cases where the decree is by a court lacking inherent jurisdiction or is a nullity that the same is rendered nonist and is thus unexecutable. An erroneous decree cannot be equal with one which is a nullity. There is no intervening developments as well as to render the decree unexecutable. Then, my lord, section 47 is discussed in para 21. It's the same principle. And then kindly have para 23 on the next page. Though this view has been echoed time out of number in similar pronouncement of this court, so and so, while dwelling on the scope of 47, it was ruled that the powers of the court thereunder are quite different and much narrower than those under appeal, revision, or review. It was reiterated that the exercise of power under 47 of the court is microscopic and lies in a very narrow inspection whole, and an executing court cannot allow objection to the executability of the decree if it is found that same is void ab initio and is nullity.
Can allow.
Can allow the objection to the executability of the decree if it is found that the same is void ab initio and is a nullity, apart from the ground that it is not capable of execution under the law, either because the same was passed in ignorance of such provisions of law, or the law was promulgated making a decree unexecutable after its passing. None of the above eventualities as recognized in law rendering a decree unexecutable exists in the hand. So, my lords, it's wrong. In law, in facts, no ground. Only if it's a nullity. And that too, you will argue when under order 21, 22 it proceeds. Under order 21, rule 23, you will file your objection, show it's a nullity. Now, my lords, after this, kindly have Vasudev, which is in that inner... That's all right. My lords may also note paragraph... Oh, I see. So the same paragraph is... Oh, sorry. My lords, in the same paragraph, I'm so sorry, my lords, in the same judgment, rather than going to the judgment separately, para 22, please have... it cites Vasudev and just have para 6 of Vasudev reproduced in para 22.
Para 22.
22 on page 442 of...
Yes.
Breakwell reproduces Vasudev Dhanji Bhai, my lords.
Yes.
These are para 6. A court executing a decree cannot go behind the decree between the parties or their representatives. It must take the decree according to its tenor and cannot entertain any objection that the decree was incorrect in law or facts. Until it is set aside by an appropriate proceeding in appeal or revision, a decree, even if it is erroneous, is still binding between the parties. So, my lords, that whole thing that it covered assets, it could not have, not done it. Firstly, those are matters to be challenged. You didn't. And if at all you think it comes within the narrow scope of jurisdictional nullity, according to me, it doesn't. Presuming your objections are correct and it comes within the narrow jurisdiction, then you raise it. But you can't move your chamber summons in my matter and say, declare the award a nullity. And then say that treat it as a section 47. I'll just show the pleadings in that chamber summon. Can it be treated as a section 47 as they're seeking? And in my order 21, rule 22, where the court also says, let's proceed with it. And both places protects you. You come into LPS and get a stay on the execution. Now, my lords, kindly after this, have firstly, my lords, the chamber summon. My lords can take it that I mentioned that earlier they had moved a suit, praying that declare the award a nullity. That is pending. And my instructions are that the ad interim injunction was not granted to them there. In any case, that suit is pending and we had raised the issue of maintainability there. But be that as it may, they also move a chamber summon in an execution. Now, my lords, I put a question to myself in my execution proceedings. Firstly, you already filed a suit. Whether that's maintainable or not is a separate issue, will be decided. How does a chamber summon lie in my execution proceedings to declare an award a nullity? It's a remedy unheard of in law, unknown to the Arbitration Act. And now kindly have what is the pleading in the chamber summon? Manoj, this would your lordships for a minute be kind enough to come to the second civil appeal, because that's there are two civil appeals they've filed.
Second.
1028 of 2019.
Only 102. One zero 1.1. 101.1. Which page, Mr. Kaul?
Page 400, my lord. It starts at 398 at page 400.
Next volume. Second one.
Volume 2. Volume 2? Volume 2.
So wait, I'll take. Yes.
My lords have page 400.
400.
Chamber summons. Let all parties attend before a so-and-so in the forenoon or soon thereafter, as the council can be heard by the council or the part of the applicant above named by the following orders. This honorable court may be pleased to declare that impugned award dated so is a nullity, null and void, non-est in the eyes of law, not binding upon the estate of late Kantilal, respondents, and the same be set aside, having been obtained by fraud, misrepresentation, misleading statements and contentions, non-disclosure of relevant material and documents, and consequently execution proceedings be dismissed. B. In alternative to prayer A, above, this court may be pleased to declare the decretal amount claimed so-and-so stands either fully satisfied or to the extent as this honorable court may deem fit and necessary. Consequently, the estate of so-and-so stand discharged. C. Pending the hearing of final disposal of this chamber summons, this court be pleased to issue summons notice calling upon the arbitrator so-and-so having addressed so-and-so to produce all papers and proceedings and all such documents filed by the claimant or the late Kantilal in the arbitration proceeding. D. Pending hearing and final disposal of this, be pleased to direct claimant to produce all documents. E. Thus be pleased to direct claimant to make an affidavit setting out in details of all assets, including movable and immovable, held by the late Kantilal on the date of the impugned order, so-and-so. And then F. Pending hearing and final disposal of this chamber summons, this court may be pleased to stay the present execution proceedings and or execution or implementation of the impugned award execution. And then it goes on. So, my lords, only prayers, no pleading, declare it nullity, and these are my prayers. Now, my lords, please see the two, and I move, of course, order 21, rule 22, because 2 years have elapsed, notice has to be given. And I also move an application under order 21, rule 41, that you must disclose the assets, because after all, you're the executor of the will of the late Kantilal. So you must declare the assets that Kantilal had, who is the judgment debtor in the matter. Now, please see the two orders which come to be passed in the matter. Kindly have, firstly this one. In the same file, my lords, I'll deal, then I'll come to the other one.
When we replace the extra, that's where the orders. So IA 132057.
In this very.
In this civil appeal.
My lords, I had, in fact, I'm instructed to say that they had moved an IA 132057 to replace that order, which is in your lordship's file, to place on record the correct order in the chamber summons. Is that what you're saying? So, my lords, we have moved an IA 132057 of 2018, wherein that order passed by the court, executing court, in the chamber summons is contained. In their chamber summons is contained. Then I'll come to the file I was first referring to.
You filed another copy and you replaced it.
Yes.
There was some issue with that.
Yes, there was some issue.
It was the same order in the second.
I see.
Right.
Oh. So please have, my lords, this
An extra A at page 7.
annexure A at page 7.
3207. Which page of the IA? 18 December.
Yes. But this is 8. This is para 8. My lord, this is at page 11. My lord has that?
Starts at 7?
Yes. This whole is para 8.
Yes.
Huh?
This is correct.
This one is para.
Yes.
Yes.
Another, it may be mentioned that a reading of the award does not show itself having been accentuated by fraud or to be illegal under any provision of any statute. The reference to arbitration by Bharat as well as Kantilal is not in dispute. What is sought to be shown by the applicant is that Kantilal appears to have lost confidence in the arbitrator and challenged the procedure adopted by the arbitrator. The arbitrator ruled on the challenge to the procedure. The arbitrator continued with the arbitration. Bharat attended the arbitration. Kantilal failed to attend it. Kantilal had knowledge of the award being passed. Kantilal mentioned about the award in his letter dated so-and-so, written less than a fortnight after the award was passed. Kantilal stated that he would challenge that award, but did not challenge. Kantilal have challenged the award. He allowed the award to become final. Then kindly have, my lords, paragraph 12 at page 13. It is for the party making the tall claim of fraud to specify the particulars of the fraud and to substantiate the allegations of fraud. The fraud is claimed in this matter is upon reliance being placed on an account of 4 family members, of which parties to the arbitration were 2 of the family members. They also happen to be partners in a partnership. My lords, has that?
Yes. Yes.
I read it again, my lords.
No, not next. Go ahead.
The account relied upon by Bharat in the arbitration and considered by arbitrator is the same as the account produced by the applicant. The arbitrator referred to as the account which came so-and-so. The applicant has produced the account statement precisely. The total funds mentioned by the arbitrator in the para so-and-so is precisely the figure shown. My lords, that is on the merits, then it deals with it. And then kindly have para 22. First have para 22. Page 18.
Yes.
My lords, have para 22?
Yes.
The basis of the account admittedly written by Kantilal cannot be understood in the absence of the case of Kantilal either before the arbitrator in arbitration or before the court in challenge to the award. Hence, except for the fact that the properties of the applicant cannot be taken in execution of this award, and the applicant is not individually bound by the award has attained finality as against the estate of Kantilal. What more will the executing court say? And now please have, my lords, paragraph 27, which starts at page 20. My lords, has that?
Yes.
The award has already come to be final. It is for the Bharat to execute the award. Upon the application of the applicant, neither can the award be set aside under the provisions of the Arbitration and Conciliation Act, nor can it be declared a nullity or non-est as claimed by the applicant. The title of any other party, including applicant, would be seen upon the attachment levied in execution. This chamber summon taken out by the applicant is premature. The directions claimed against the arbitrator are impertinent. Direction to the claimant, who is the award creditor, to give details of assets to the executor of the state of the award is rather illegal. The stay of execution proceedings is not warranted. The entire application is completely misconceived and is dismissed with costs of 1 lakh. The execution shall proceed in accordance with law. And he says, when I deal with attachment and others, your issue of your properties will come in. And now, my lords, kindly have, in the first matter that I was arguing, where in my chamber summons under order 21 rule 22 notice is issued and it's allowed to proceed, the order which comes to be passed, because that's also impugned in an LPA. Kindly have page 430 of that SLP, which is 1026. Volume 2.
Volume 2 in item 101.
At 433. Four, my lord, it starts at 430.
430. That's 433, you said.
Yes. My lord, it starts at 430.
Yes.
On 431 para 2, they note the fact that, my lords, the award has been passed more than 2 years prior to the application.
Yes.
Under order 21 rule 22. Then have para 6 on page 433, my lords. Since number 1 claims to be the executor of the estate, he is required to provide the aforesaid particulars under provisions of order 21 Rule 41 of the CPC. The other respondents are not award debtors and need not provide the particulars called for. Then para 7. Respondent number 1 has filed an affidavit giving details of certain movable and immovable properties. Most of the properties have been detailed by the applicant claimant himself. That part of the affidavit is in the nature of explaining how the assets and properties detailed by the claimant do not form a part of the estate of the deceased. That is not the purport or the ambit of an application under Order 21, Rule 41 of the CPC. Be that as it may, it is for the applicant claimant to proceed in execution by attachment or otherwise of the properties, which attachment shall be considered at appropriate time upon application made in accordance with law. So there, in their chamber summons, here in my chamber summons, adequately protecting his interests, but they say you can't in an Order 21, Rule 41 for disclosure of assets start talking about your assets. And it will be protected when the time comes to attach it or an attachment is sought. Then, my lords, may kindly have para 8. It's now, my lords, para 10. Please have para 10.
Yes.
Hence the following order. My lords has that? Para 10 on page 434. Hence the following order. Notice under Order 21, Rule 22 of CPC to proceed in execution of the award is granted as the claimant award holder has not been provided full knowledge and information of the entire state of the award debtor. B, the applicant claimant shall be entitled to proceed in execution in accordance with law. C, if the award stands satisfied upon the aforesaid particulars, no further directions would be required to be passed for further properties of the award debtor, since decedent is irrespective of his estate. D, if, however, the award still remains unsatisfied after proceeding in the execution in respect of the known properties, movable and immovable of the deceased award debtor, further particulars may be sought by the applicant and claimant in a further such application. And now, my lords, this comes to be challenged by way of these two orders by two LPAs. Now, my lords, in 2015, the LPA is filed. We take objections to maintainability. In 2017, Girdhari Lal, who was the executor, passes away. His son is brought on record. And after that, my lords, the common impugned order comes to be passed, which is on page 6 March 2018. Starts at page 1, but please have the main part on page 4. No, subject to, sorry, no, my lords, first page 1. Sorry, my lords, first page 1. Page 1.
Yes.
My lords have that. Para 2, subject to maintainability, both appeals are admitted. And then, my lords, please have page 4. Para 2 onwards. We have heard the learned senior counsel for the applicant and the learned counsel for the respondent. Considering the grounds of appeal and submission in advance, we have admitted the appeals. The learned senior counsel place for interim relief as execution proceedings are already initiated by the respondent. It is submitted that if the execution proceedings are allowed to be proceeded with, then the purpose of filing appeals will get frustrated. We are prima facie convinced that pending hearing and final disposal of the appeals, operation of the impugned order dated so and is required to be stayed and suspended. Pending the hearing and final disposal of the appeals, operation of the impugned order dated so and so is stayed. No discussion. Why stay is being granted? What is the case made out? And after 3 years, a blanket stay on execution proceedings is given and says maintainability will be considered when the matter is heard after admission.
Yes.
Now, my lords, firstly, my lords, whatever objections you need to file, whether they are entertainable or not, it is within a very limited scope. Whatever it is, you will do as the execution proceeds under Order 21, Rule 23, or otherwise. As the court has said, you raise it when the attachment and other issues come up. Merits, in any case, you can't get behind the decree. Who are you? Between the parties, it's become final. You are the executor. You are moving chamber summons in my execution proceedings for declaring an award as a nullity when your own suit is pending, which itself is not maintainable. Now, my lords, even the judgments that could be, I'm anticipating, relied on. I'll just deal with those 3 or 4 judgments which will have no bearing at all. Firstly, my lords, as I respectfully submitted, that electro steel was yes, my lords, in electro steel, why the court interfered under 47 was, as I had already mentioned, one of the grounds taken was that there was no challenge under 34.
What the citation?
My lords, the citation is 2025 7 SCC 773.
What copies also?
Yes, yes, my lords, we have copies. So if 48 is the same one, just see 48.1. I don't want the 48.1 they could.
Yes.
Huh? Now, my lord, let me just very briefly again repeat that. There's some relevance. There is an arbitration proceeding.
No matter will take the rest of the days. The court can stand discharged.
My lords, there is an award rendered by the West Bengal Micro, Small and Medium Facilitation Council. Lords knows those MSME councils dispatch awards. In the meantime, in an IBC proceeding, the claims stand extinguished. No 34 is filed. When the award is sought to be executed, section 47, objection is taken or pleas are taken. The argument raised was that you haven't challenged it under 34, how could 47 lie? The court said, look, we are not getting into merits of the award. We are not getting into whether it's legal. We are getting into a jurisdictional nullity. If there is no arbitrable claim, then what award are you passing? It's a jurisdictional nullity. That is why we will entertain the 47 and pass the order. And so, my lords, electro steel is of no help or assistance to the respondents at all in this matter. Now, my lords, another case which came up to this court, and in fact, I should have shown that provision to your lordships. Would your lordships be kind enough to have section 17 of the Arbitration Act for a minute, my lords? Because this is that Amazon versus Future Retail judgment, which came to the Supreme Court. Just have para 17 for a minute, my lords. Sorry, section 17 of the Arbitration and Conciliation Act 1996. Para 2. Subsection 2. Subject to any orders passed in an appeal under section 37, any order issued by arbitral tribunal under this section shall be deemed to be an order of the court for all purposes and shall be enforceable under the Code of Civil Procedure in the same manner as if it were an order of the court. These are 17 start with interim measures, orders by tribunal. So against interim orders, it's 17 as you come under 34 for final awards. So in Amazon, my lords, an emergency award came to be passed. The facts are not so important, but basically an emergency award came to be passed. Net, someone interfered, someone didn't. The LPA was filed therein. Supreme Court ultimately said that you can't treat it as an order of the court under CPC. It is still under the Arbitration Act. It's not under the CPC, and an LPA will not lie against that. Now, while passing that, in that judgment, also reliance was placed on section 36 of the Arbitration Act, where the words as if it were a decree of the court are used. And judgments, the ones I was citing, Infuse, De Lawson, etc., were cited there. The court said 36 is not the issue. We are dealing with 17, and we are not commenting on correctness of the 36 judgments. That's all that it said. It didn't say those judgments are wrong, because 17 was directly the issue. And 17 also deals with the words shall be enforceable under the Code of Civil Procedure in the same manner as if it were an order of the court. And they said this can't be treated as an order under Civil Procedure Code, and LPA will not lie. So to 17 also, the court applied the same principle. 36 was in the passing mentioned because the party relied on 36 to buttress its submission that an LPA does not lie. The court said we are not dealing with the scope of 36 or the judgment parts under 36. That is, but it does help me because as far as 17 is concerned, it says an LPA will not lie. And there, my lords, may kindly have just para 75 on page 279 of the judgment compilation. Well, my apologies. Actually, I should have shown one paragraph of electrosteel to your lordship. I'll go back to that. I'm so sorry. I just skipped my mind completely. But first have this paragraph 75, my lords.
The judgment compilation.
Yes, my lords. Judgment compilation, page 279.
Yes.
My lords have that?
Yes.
There can be no doubt that the legal fiction created under 17(2) for an enforcement of interim orders is created only for the limited purpose of enforcement as a decree of the court. To the extent this fiction to encompass appeals from such orders is to go beyond the clear intention of the legislature. To extend this fiction, to encompass appeals from such orders is to go beyond the clear intention of the legislature. So-and-so's argument in stressing the words under the Code of Civil Procedure in section so-and-so thus holds no water as a limited fiction for the purpose of enforcement cannot be elevated to the level of a genie which has been released from a statutory provision and which would encompass matters never in contemplation of the legislature. Even under 17. And now, my lords, in electrosteel, which I handed over an individual copy, just have, my lords, for a minute, one paragraph I needed to show to your lordships. Kindly have paragraph 48.1. On internal page 38 of the judgment, the internal page is given at the bottom, my lords.
Yes.
My lords has 48.1 on page 38. Section 47 CPC deals with questions to be determined by the court executing decree, As per subsection 1, all questions arising between the parties to the suit in which the decree was passed and relating to the execution, discharge, or satisfaction of the decree shall be determined by the court executing the decree and not by a separate suit. That's another issue, my lords, which I'll take in that. Execution of decrees and orders is provided for in order 21. Law is well settled that at the stage of execution, an objection as to the executability of the decree can be raised, but such objection is limited to the ground of jurisdictional infirmity or voidness. The law laid down by this court in Vasudev is that only a decree which is a nullity can be the subject matter of objection under section 47 CPC and not one which is erroneous either in law or facts. The aforesaid position of law continues to hold the field. Then 49. Objections to the execution of an award under 47 is not dependent or contingent upon filing a petition under 34. High Court was not justifying taking a view that since the appellant did not file a petition under 34, therefore it was precluded from filing an application before the High Court, executing court to declare the award as void and hence non-executable. So you can file it, provided it's a nullity. Not on merits or it's erroneous. On that limited scope, 47 will lie. And then, my lords, 52 of the same judgment on page 42. My lords has. Yeah,
Not that it is relevant for your case, but this sentence, this beginning sentence in para 49, that might create trouble in some future case. That it is not contingent upon 34 being moved. That might, if suppose it is, this very same objection has been raised in 34 and rejected, does it mean that it can still be raised again in 47?
My lords,
Because they say it's not contingent upon or dependent upon, not dependent or contingent upon. But they should have at least clarified that it should be an objection which was not already considered and rejected under 34. And
No, Lordship are absolutely right.
if they don't say that,
Absolutely right. I'm just attempting an answer, if that were to be taken, that possibly they qualified it the word, taking the view that since the applicant did not file a petition.
in that case, no.
In that case.
But this
Yes, no, but
observation
I'm just,
is little too general.
I get what your lordships are saying. I'm just trying to. Would
Yes.
your lordships have para 52? In that view of the matter, we have no hesitation to hold that upon approval of the resolution. In that view of the matter, we have no hesitation to hold that upon approval of the resolution plan by the NCLT, the claim of the respondent being outside the purview of the resolution plan stood extinguished. Therefore, the award dated so-and-so is incapable of being executed. Consequently, so-and-so. So, my lord, that was the context of electrosteel.
That observation will have to be conditioned by the facts of that.
Absolutely. It can't be just picked up and cited. So, my lords, this is as far as Amazon I have already mentioned. This is electrosteel. Then, my lords, another judgment they seek to rely on is Babulal Khimji. Now, my lords, if your lordships will recollect that in Babulal Khimji, the issue was that if a certain appeal is not mentioned under a 43 Rule 1, then how can an appeal lie under the Civil Procedure Code? The court said that all nature of orders passed under 43 Rule 1 have a color and tenor of finality of judgments. So we can take the same blush, the same color, and say that if something is a matter of moment or has a finality attached to it, an appeal could lie under 43 Rule 1, though not mentioned therein. And one of the instances given there was of something which is not mentioned in Order 43, is an order granting or refusing to stay execution of a decree. Now, my lord, surely that can't be interpreted to mean that under the Arbitration Act, because it's an execution proceeding, an LPA will lie. Because no one has stayed the execution of a decree. Is that the extent you will take a self-contained court to be strictly interpreted to say that in view of Babulal Khimji? No, and all those judgments, Tuesday, Lawson, etc., all go out of the window. Babulal Khimji, in its facts, under the Civil Procedure Code, Arbitration Act not being considered neither Commercial Courts Act nor Arbitration Act, which are special legislations intended for speedy disposal. Under commercial courts also, your lordships knows the same nature of arguments have been made under Section 13, but more so under the Arbitration Act. Yes. You're completely destroying the spirit. Then, my lords, LPA could yes. Now, my lords, another judgment which could be relied on, I don't know, is a Lakshman Surve judgment of the Bombay High Court, effectively on the point that if under 21 Rule 23, your objection to execution, your lordships will recollect Order 21, Rule 23, Sub-Rule 2 said that you can file objection. If that is ruled against you, you can file an LPA. Yes. Right, my lords? Now, my lords, firstly, that is not a case dealing with arbitration at all. Secondly, in that context, they said under Order 21, Rule 23(2), if an objection is rejected, you could file an LPA, not under the Arbitration Act. An LPA can't lie. So, my lords, none of the judgments that I anticipate could be relied on come to the aid and assistance of theirs to say that an LPA could lie. My respectful submission, my lords, is that it would do great violence to the letter, spirit, and object of the Arbitration Act, if such as the court said that you are unleashing a genie where you encompass everything which is not contemplated by the legislature in the matter. And if this were the case, my lords, today to say that the award, the best two arguments they can make are, these are my assets. These are not the assets of the judgment debtor. That you have been sufficiently protected. B, it was a fraud played by the arbitrator, etc. And the Kantilal did not participate. Now, my lords, what is to be kept in mind is, firstly, Kantilal jointly appointed this arbitrator. Secondly, after the award, he wrote, I will challenge it, and never challenged it.
He wrote to the arbitrator.
He wrote that I will challenge it. My lords, I need to just show to your lordships that. Please have page 48.
First or the second one?
The first volume.
First one.
Yes. Now, my lords, kindly have. He first on page 48 and 49, my lords, raises all his concerns disturbing, and just have page 450, my lords. My lords, has page 50. The arbitrator is, in my view, arbitration in my view is irregular and void, and there is no force of law in the award passed by you. I will resist through all legal remedies and recourse available to me. And he does not file any 34 against it, my lords. And on page 51, it is confirmed from the High Court that no 34 has been filed in the matter. Right, my lords? Now, after this, my lords, 3 years after this, this party files a suit for declaration that the award is a nullity. You have this here? 18/7/2013? Huh? Files a suit where he asks for, firstly, the suit we raise an objection is not maintainable. That will be decided. The suit is pending. He also asks for interim relief. Now, kindly have, my lords, page 166 for a minute. My lords, has that? 166 and extra P13.
Yes.
The grievance of the plaintiff in the above suit is that the award obtained by so-and-so against his deceased father includes properties which belong to the plaintiff, who was admittedly not made party to the arbitration proceedings. Admittedly, the plaintiff gained knowledge quid the said award as far back as 2011, entered into correspondence with the defendants on March 2013, filed the present suit on 17/5/2013, and has moved an urgent ad interim relief only on 8/7/2000 today. In view thereof, no ad interim reliefs are granted in favor of the plaintiff. Now, when I file the execution, you again move a chamber summon for declaring it a nullity in the eyes of law and ask for interim reliefs there. So your suit, whether maintainable, not maintainable, is pending. Ad interim relief rejected because of delay. You again move a chamber summon saying that declare it a nullity. On the face of it, not maintainable, also pray for interim reliefs, which have been rejected here in the suit. And then when the two orders against you come, you file LPAs in which the impugned order is being passed. That's, I'm very, very grateful, my lords.
Sorry?
Their request it be kept the following week.
You have 45 minutes now.
27 Jan.
Whatever it is, you can make a beginning. We've discharged the board. You kept quiet when we discharged the board. Do you not understand what discharging the board means? We asked the learned senior counsel whether the matter would take the rest of the day. He said yes. You say nothing. Now your turn comes and you ask for an adjournment. That's not fair on your part. Were you taking a nap? Were you taking a nap then? Counsel, you ought to have told us that beforehand. And what was your colleague doing when we were discharging the board then?
Anyway, that it's a complete misunderstanding.
We don't like wasting our time. We are here till 4 o'clock. So you need to keep us occupied till 4 o'clock. Let your colleague argue if you're under the weather. If it is judgments that are to be cited, he can cite them on your behalf. You can take your seat guide him as to which judgments he needs to cite before us? Even at that stage, you said you did not tell us that you would not take your turn today.
Let me give my or the scope of my response, so that I'm not shying away from anything. I've been appearing in this matter right since inception, so that I do have a very.
Speak into the microphone, please.
I'm sorry. I said I don't wish to shy away from my responsibility. I will take it. I was only claiming this seeking this indulgence because I'd be at my best on the next occasion, but nonetheless, Now, my lord, virtually without exception, every single judgment that my learned friend has relied upon is between the parties to the arbitration. There is no exception to that. My case is that is Girdalal Dalal was not a party to the arbitration, notwithstanding that chapter and verse, all his assets have been attached and given to Bharat Dalal, the claimant. That's it. Now, that will not, I'll show from the award itself how he proceeds to decide the matter against my client. He says, Bharat Dalal, that's the claimant, told us that unanimously Kantilal, that's his father, had my permission and the permission of my nephew, that's Surendra Dalal, to represent them in the course of arbitration. There is not a scrap of paper in writing in which this authority has been given to Kantilal Dalal to arbitrate or to agree to an arbitration on.
Were you shown as parties to the arbitration award in the cost title?
I'm sorry. No.
Oh, then it's only the father then.
That's right. Now, this therefore, just a minute. This therefore is a nullity, if anything is a nullity. It's a decision which involves strangers to the arbitration.
Where does the award say so?
Let me show that. Let me show that immediately. Yeah. That's one. And I'll tell my lord what the other aspects of the nullity are.
So let us first see the award itself, whether the award reads to this effect that it affects.
I'm going to request my learned junior to read
Very
it.
Let him read it.
I have a problem with that.
Page number 20 is the award.
Speak into the microphone, please.
Page 20 of the award.
28. Page?
20, P1, annexure P1 is the award.
Yes. First, let us see the cost title.
Yes.
It only mentions Kantilal Dalal.
That's right.
Very well. Then, where do you find mention of the others being also party to this proceeding?
Page 21, para 1.2 is basic dispute which was raised before the arbitrator.
Yes.
1.2, on or around 7 May 2008, Bharat approached stating that certain dispute has arisen amongst the family members and not just Kantilal, and requested me to act as a sole arbitrator in the matter, as he himself and his father Kantilal so desired, as they both had trust in my professional experience and acumen. At the time, I had agreed to act as the sole arbitrator, provided both of them appointed me in writing under their respective signature. Nothing happened till February 2009, till 9 months after 7 May 2008. However, I received a letter. Your Lordship may skip this. Then, Your Lordship, para 2.1 is the actual dispute which was referred with respect to distribution of a joint account which belongs to 4 people. And this arbitration is amongst 2 people, Your Lordship. 2.1, Bharat stated the following issues for arbitration, wide letter dated 2009, 11 May. Improper accounting and distribution of family funds. During 96-97, family onshore business was split. The other assets were also liable and demanded to be disbursed. It was also going it was during end March 2001, the actual disbursement took place. The bank statement not disclosed. However, disbursement took place on assumption A, verbal warranty on a total family corpus. Cash balance is assumed held at one bank. maximum 18.87 million during 31st January 1997, and further up to 19th March 2001, interest at rate of 5% per annum was assumed, and total funds were assumed at 21.87 as on 26th March 2001. Whereas on 19th March 1992, the same bank held funds at least 25 million based on exchange rate prevailing during March 1997 as per details and bank statement as available.
No, just for a minute. This 25 million has never ever been substantiated. Not once in the entire award. But I'm going to make a comment over here. Now, these were accounts maintained by Kantilal Dalal in ABN AMRO Bank, London. And these amounts emanated from a business, Kantilal and Company, conducted in Bombay. Now, this was brought to the appeal court, that there must be some semblance, some way to establish that these are legitimately taken to a foreign shore. Because in the absence of that, this entire bank holdings, bank accounts in a foreign account violates FERA, violates the provisions of the Foreign Exchange Regulation Act. Entirely through the award, not a scrap of paper to show that there was any RBI permission when these account holders are resident Indians. Now, both these aspects, one, that the dispute which was raised in the arbitration is only between father and son, dealing with amounts held by other family members, all four of them. Those other two don't have a say, never come into the equation. They are not. Now, this, therefore, my lord, is my first submission that this by itself makes the award a nullity because it deals with assets of strangers who are not privy, who are not parties to the arbitration. Not considered at all by anyone. Not considered. In fact, when this was argued before the single judge, she says, but which provision of FERA has been violated? That's a way of dismissing it. Therefore, my lord, my first submission would be on both these counts, the award is a nullity. Now let me show you how the assets belonging to the others have been merrily distributed and handed out by the arbitrator to Bharat Dalal. And that, your lordship, will find chapter and verse. Yes.
Para B is dealing with bank statement as on March 1997.
Which para are you reading?
B 2.1 B was distribution of the bank statement as on March 1997. And in their reply, they have admitted the percentage which was each 4 people who was entitled to at page 174, your lordship. This shows that all 4 were necessary parties.
Verbal warranty and total.
And the percentage was as follows. Kantilal Dalal had a 24% stake in the funds. Girdharlal Dalal, that's my client, had 34%. And the other two, Surinder Dalal and Bharat Dalal, who was a claimant.
This is the London bank account.
That's right. Now, all
This London bank account is a joint account.
It's a joint account.
We have produced it in our chambers.
And therefore, if the arbitrator takes it upon himself to distribute as the proceeds of a joint account, he can't do it without 2 of the persons.
No, but why can't you raise all these issues before the executing court?
That we have.
If you, no, but you have now stalled the proceedings. The executing court says that all these issues will be looked into. It is not as if your claim was rejected outright. These are all points to be looked into. Let the execution proceedings go on is what the executing court said at that point of time.
First time that execution proceedings have commenced against me. I was a party to the execution proceeding.
Now, this proceeding, you are in that picture in the capacity of being the executor of Kantilal.
Capacity.
In your personal capacity. Where do you get that?
Let's show that. Yes, ma'am. Yes. That's in our reply, a reply to our
No,
chairperson.
in the execution petition, how are you described?
I'll show you. Just kindly see.
This one. Lordship, page 188, paragraph 27. This is reply filed by them to our
No.
member summons.
Show us the execution petition, please. Where is the execution petition?
Page 308 is the execution petition.
The first volume, first matter.
Page 310. Volume 2 and
Volume
describes
two.
legal representatives and executors of Kanti Lal. Heirs, beneficiaries and executors of Kanti Lal. Page 310.
310. Legal heirs and beneficiaries.
Legal heirs and or beneficiaries and or the executors of the estate appointed under the will so-and-so or the purported will dated so-and-so.
Before I went to execution, I wrote.
So under the will, all of them are the legatees.
No, some of them are. That is, I said and or.
And all.
That's why.
Show me where.
And in
So
fact,
you are implemented as the legal representatives or the executors,
As an individual capacity.
not in your individual capacity. Where does it mention individual capacity?
Page 188, paragraph 20, volume 1, paragraph 27.
That is your reply.
They replied to our chamber
They
summons.
reply to it.
188.
188.
$188,
Paragraph
Yes.
27, your lordship.
27.
Volume. May I? Kantilal, however, admittedly did not challenge the award. The award has become final and binding and exuberant. It is respectfully submitted that the award is not only final and binding on Kantilal, but also on the plaintiff, both as purported executor appointed under the will of Kantilal and in his individual capacity, as he had consented to the said proceedings and or in any event acquiesced to the same, and is therefore estopped from asserting his own rights, interest in the subject matter.
Now let me show you, let me show your lordships how he assumes that Girdalal Dalal has given, show from
So
the
before
award.
that, page 174, your lordship, page 174, volume 1. Yeah, yes, sir. First line, the profit and loss sharing. Yeah.
How do you address the issue of maintainability first?
So this is the profit and loss sharing ratio in Kantilal from joint.
First, let's get over the maintainability issue. After that, you can go to the
No,
merits.
maintainable is this.
So far as all these aspects are concerned, we still don't get it as to why you can't go before the executing court and raise all these grounds. Now you are also supported by the judgment in Electro Steel. If you are in a position to show the executing court that this is a nullity, this award is a nullity,
I'll show that.
then 47 objection would always be entertained.
Exactly that. I've raised 5 or 6 grounds.
It has not been rejected.
It's rejected in terms. In terms.
You ask for a peremptory declaration that the award is a nullity, without any pleadings, without any objections being raised with supporting material.
He did.
We have seen your chamber summons, counsel.
The affidavit is not so.
Let me show you from the
The
affidavit.
The executing court merely says that at this stage I cannot do it. All issues can be looked into.
That's the
That aspect we can clarify that issue will be looked into.
That's the appeal
But
court.
how is your LPA maintainable is the first issue.
Exactly what I'm coming to. It's maintainable on 2 counts, 2 or 3 counts. One is that my assets have been distributed by the arbitrator without me being a party to the arbitration.
That doesn't mean that you can override the Arbitration and Conciliation Act and go to the CPC.
Party to arbitration proceedings, they can't deal with my property. The arbitration,
Your remedy is provided in the execution petition now. How is the appeal maintainable?
I'm entitled to call it a nullity or prove that it's a nullity if it goes beyond the ambit of the Arbitration Act. If I'm not a party to arbitration proceedings, my assets can't be dealt with. I'm a
That is
stranger.
an issue which you will prove before the executing court. Executing court has already observed that if your assets are the ones that he wants to proceed against, that will be excluded. That assurance is already given to you that it will be looked into.
Matter of
How is the appeal maintainable? Don't link it up with the other issue. Your issue, the appeal maintainability in relation to a special legislation, that is a separate issue altogether.
the award, how it merely distributes.
Again, you are linking up both matters.
Yes.
This is a special legislation. 37 appeals alone are permissible. There is no question of going to the clause 15 of the letters patent and enlarging the scope of the appeal provision there.
That concern in the following manner. Scope of why the Arbitration Act does not permit any challenge as far as the enforcement is concerned.
You also filed a suit which is pending.
But that's a separate issue altogether. Let me make my submissions. The Arbitration Act is a self-contained code only between the parties to the arbitration. It can't go beyond that. The minute it exceeds that, it's for that reason that the enforceability of an award cannot be challenged, can only be challenged by a person who's, or rather, the provisions of appeal are only confined to those who are parties to the arbitration. The minute a stranger is affected by an award.
Come to section 34.
Yes, that's right.
It is not applicable. We are plotting in
That's-
section order 20.
The 34 is not.
34 of the Arbitration and Conciliation Act, where does it limit it only to the parties to the arbitration?
It must necessarily.
It specifically says arbitral award deals with a dispute not contemplated by or not falling within the terms of the submission to the arbitration, or it contains decisions on matters beyond the scope of the submission to the arbitration, will obviously be set aside under 34. So even under 34, you could have maintained an application. You could have maintained an application because the arbitrator has dealt with issues beyond the scope of the arbitration. You did not do that though. According to the other side, you had knowledge of these proceedings and you acquiesced in them.
Their case, that Girdalal Dalal didn't act as the executor, he didn't exercise his rights. But I'm not exercising my rights as.
In any event, you are shown here as a party to the execution as the executor of the will of Kantilal Dalal. So you cannot now say that I'm an independent party to the execution proceeding. You are not.
Point out, my lord,
They
how-
may have said that you are bound by it individually, but so far as the execution petition is concerned, you're shown there as a party in your capacity as the executor of the will of Kantilal Dalal.
in the execution proceeding, and also I read out, in his individual capacity.
That is, they say that you're bound by the award, but you're shown as a party to the execution only in the capacity of being the executor. Therefore, you can't enlarge the scope of your role there and say that I will maintain an appeal in my individual capacity.
Show you how the assets are distributed in the award.
That is again on the merits council. We are asking you about the maintainability. We are not getting an answer. You are trying to link up all the issues and tie it up in knots. That will not be possible.
If an award is to a person, not a party to the award, it's a nullity.
Well, you file a suit, you pursue your suit for what it's worth.
Look, that suit is.
So far as the execution petition is concerned, that does not involve you in your individual capacity.
But it's an appeal maintainable under 21.
So far as.
21.
So far as the section 36 is applicable is between.
You are only there to assist, not to argue again.
Just to clarify that this is an appeal under order 31. Enforcement is different from execution, which is the Amazon case says. Enforcement is different, execution is different. I am brought as a party in an execution proceedings, and in an execution proceedings, I am not really concerned with the impact of implied exclusion under 36. It is in the execution proceedings, any order which tantamounts to a judgment is appealable, and Amazon judgment itself says, Sundaram Finance itself says, and Vedanta Finance, line of judgment which would be applicable. Here I am not being brought. as
That
a
does not apply to these kind of cases.
But
Not
the
to,
judgment says that the difference in
we have
enforcement.
already seen Amazon, that is not how it reads.
The judgment distinguishes between enforcement as a different thing from an execution proceeding. Execution necessarily has to be under CPC where you cannot.
It is
rely-
executable like a decree.
And to be executed under the CPC, it doesn't take your lordship.
You can raise a 47 objection if you have the ground of nullity or the award being void. That objection is still available to you, but that does not mean that you maintain an appeal against the order of the executing court directing the execution proceedings to go on.
I have taken that objection, that it's a nullity in the execution proceedings. That's been held against.
That's your chamber summons with nothing else.
That's my response to the execution proceedings.
Not by way of a chamber summons with nothing else. You've not even raised an objection under 47.
Affidavit support is fine.
Affidavit in support, all this chapter and verse. Now, this has been rejected by a single judge. Now, my lord, let me just put.
So
make
may
my
I just say
position
page
as-
137 affidavit in
Yes.
support.
Now, I'll just point out from the affidavit in support, page 137. The kindly see, I have taken every single objection.
Let us see your affidavit filed in
Page
support of the
137.
chamber. Which page is it?
Page 137 to a counter, which is
171.
137.
One 137. Your counter affidavit,
Yes, counter affidavit.
volume 3.
Just the R3. The next R3.
Your counter also runs into 3 volumes.
So it's a bulky this thing. Yes.
There's a volume 1, volume 2 also. Counter. Not 2 is not there. No, this is a rejoinder. This is a rejoinder. 139. Affidavit in support of the chambers. Yes.
Straight away paragraph. Para 1, Your Lordship. Claimant has filed the caption execution application for enforcement of the award. Your Lordship, we may skip this and paragraph 2 onwards, the impugn order is in blatant violation and contrary to the page 140 and contrary to the laws of India public policy and thus clearly unenforceable. The claimant is well aware of the illegality of the impugn award and has taken the conscious decision not to enforce the same in India during the lifetime of Kantilal. Pertinently, claimant has not explained the delay in approaching. Your Lordship, this is with respect to the delay. The grounds which are taken is paragraph 3 at page 141.
Not every single ground relating to nullity.
You raise a 34 ground there.
Yes. This
Page 142, bottom, you raise a section 34 ground.
Page 141, Your Lordship.
Impugned award transgresses the dispute submitted to arbitration, which is a ground for setting aside the award under section 34. So you could have filed an application under 34.
One is against public policy.
That is also a ground under 34.
That must necessarily, it violates section 23 of the Contract Act. You can't have, there can be no arbitrability of an illegal contract. It's as fundamental as that. Now, if amounts
You
are
do not answer the question though, counsel. You seem to beat around the bush all the time. You are not answering our question. You could have, if you were aware of the award, you could have filed a 34. For you to say that I had no remedy under 34 is not correct, because you raised 34 grounds in this now.
34 is not available to a stranger.
34 is not available to a stranger. Where do you get that? Which judgment says that it is limited only to the parties to the arbitration?
I
The provision itself doesn't say so. Where does the provision say that a party to the arbitration shall move an application?
The Arbitration Act is a self-contained act. The rationale of the Arbitration Act being a self-contained act must.
We are still not getting an answer as to how your appeal is maintainable.
Coming to that.
No, you're just going around in circles, Council. That won't help. Perhaps it is useful wherever you're practicing, but before us, we need direct answers, please. This beating around the bush will not do.
May I once again then renew my request? Would you please keep it next week? Surely that's not that unreasonable.
We will take it up next week, but this kind of arguments, please discard them and come directly to the point. When we ask a question, we expect an answer.
Accept the humiliation. Please give me a week's time. I'll come back.
Where does your affidavit end?
Embarrassing than I've ever been in an forum. But therefore, please give me a week's time. I'll come back.
Where does the affidavit end?
It runs into it. Just a minute. There. Page 175.
175.
176 is the last page. It's not being issued. 176 or 178, your lordship. What will you say? He doesn't see any, please, your lordship.
You do not mention section 47 anywhere.
No, but
Sir, nullity is mentioned.
You mentioned that, but you don't say that this is to be treated as an objection under section 47.
all the grounds under 47 have been taken by me. The nomenclature really hardly matters.
Where it suits your convenience, nomenclature matters. Where it doesn't suit your convenience, nomenclature doesn't matter.
It is a 47. It can't be anything other than a 47. There is no other remedy available to me except a 47. And it is a 47. I have taken ground relating to nullity. And not only that, but the single judge says none of these grounds have been taken. It's there in black and.
Where is that order rejecting your chamber summons?
Yes, I'll point that out. But before that, would your lordship just have a look at one facet of the award? Just one facet of the award, and I just want to show your lordship how the award goes far beyond the claim. Let's just have a look at that.
You do understand we are not on the merits of the matter though, because your appeal is pending there and their execution petition is also pending, wherein the executing court in fact says that these are aspects to be looked into.
How do I demonstrate now? Except by showing that the award is so unreasonable.
Let us see the order rejecting the chamber
Paragraph
summons.
3 of the order at page 177.
177 of the first volume.
Of the counter.
Counter itself.
R4, Annex R.
Page 177. No, this is your prayer. We are asking for the order.
Order. Volume 4, your lordship. Volume 4, so sorry. Volume 4 at page 177, Annex R.
Second SLP is it's with the IA I had showed. It's the second SLP.
Second SLP.
IA 132057 of 2018.
1320.
Your Lordship, I
Yes,
read it out
in
from
that-
here.
In that page,
At page 7, annexure A.
yes,
Paragraph 3.
paragraph 3.
The applicant would have award
Declared a nullity.
declared a nullity on various grounds, though not specified in the affidavit of support.
Then let me pause here.
Award is without jurisdiction, accentuated by fraud, violation of public policy, deals with issues of party. These issues you had not raised in
Now,
the.
now let me come to that. It's been raised over 25 pages.
FERA issue also was raised in your office.
One. Every
200
single one.
exhibits, 200 pages
With
exhibits.
200 pages exhibits. Every single one. Now, this is the slipshod manner. This is the cavalier manner in which my application has been dismissed. And I have raised it under specific heads. It's a fraud. It's beyond limit. Every aspect has been raised. That it decides matters not pertaining to the parties to the arbitration. All of them.
You had also alleged fraud, is it?
Yes. Yes. Cited judgments to that effect. And when I say violence FERA, this, which provision of FERA? You have not pointed that out?
Mr. Kaur, to this extent, perhaps this order will not preclude them from raising all grounds available to them to attack the award as a nullity.
I started by saying
You
that
said
under
so, but this
21
order would perhaps
under 21, Rule 23.
shut out some aspects because this order clinches that issue there.
I, with respect, say one thing. It's at times people are very unfair to the court. First, in your chamber summons, you move a bald chamber summon without setting out pleadings. Then in your oral arguments, you argue everything. Now, when the court,
This affidavit must have supported the change.
then the court deals with it. You say they've shut me out. Now your stage is order 21, Rule 23, subclause 2. Nullity, I have repeatedly argued, you can argue and it be dealt with. My learned friend still does not answer the question. He goes on merits repeatedly, but he doesn't answer the question, how is it maintainable? And then he goes on to say it's not.
One aspect we would have to clarify, even if we say that their appeal is not maintainable, is that this order will not preclude them
From
the
raising
force of execution.
Madam, please say so.
With regard to all aspects that are available
Madam,
to
I
them
cannot
to attack the award.
What else can I say? I
You've
start.
already said that, no doubt, but this order perhaps shuts the door on some aspects.
My difficulty is that they do not let the execution proceed at all and come by for
This order, perhaps, this order, if this order remains, that closes the door on a lot of aspects.
So many orders said, will decide order 21, Rule 23, uninfluenced by the observations made. Your Lordship has said so, but it can't be that you move a remedy which is not maintainable, and the law said I will not let
Say
it.
that this order will not preclude them from raising.
By the observations made here.
Maintainability is exactly what's kept open by the High. Your Lordship is directed to do it within 4 weeks, 6 weeks, whatever.
Why do we again need to have the High Court look into this?
May only be
All that you were bothered about was that your attack against the award had been shut out by this order, and therefore you had no remedy.
Nullity, on nullity.
On the ground of nullity.
fervent request, rather than be told I'm saved by the bells, please give me till next.
We will give you time, but we are saying that it is not necessary for you to go back to the High Court to argue your appeal. If this is the only order which is coming in your way, this order we will say will not preclude you from raising all grounds available to you to attack the award as a nullity.
Stomach my husband and request. for
It is not our intention to embarrass you,
I
counsel.
know.
Please do not.
I know
Do
you-
not misunderstand it, because here, after 17 years on the bench, speaking for myself, I can tell you, patience wears thin. Because patience, we've been told, beyond the limit ceases to be a virtue. I've long crossed that limit. So patience is no longer a virtue so far as I am concerned. So especially in this court, patience is tried day in and day out. So that is the reason why we require counsel to be precise, concise, and come to the point.
Appreciate that. I'm just making.
It is only that frustration which makes us say things, nothing intended personally against you. Please do not take it personally.
I wouldn't, I know you wouldn't. Therefore, not just keep it for weekends or whatever time suits you.
No, we'll take it up next week, next Wednesday.
That's a holiday, my lord.
Wednesday is a holiday. Thursday then. Thursday is all right?
Is it possible to do it by 2 weeks? Just asking.
Very good.
2 weeks? I'm obliged, and I once again apologize with sincerity.
12th then. 12th November.
Very
Third in part. List.
Can I? I'll leave it to your lordships. My learned friend is actually traveling thereafter.
Oh, you don't want,
He's traveling till the 16th. Would it be any date after the 16th? Or any date
19th, 19th then? 19th is not convenient.
No, it doesn't, sir. 20th?
20th it may not reach.
Any other?
Because Wednesday's matters will spill over to Thursday. So if you ask for a Thursday's date,
Any date after 20th? Any date after 20th?
26th then.
26th.
Any day that's convenient to, I'll make it a provision.
On what date? Which?
Any early day.
So lords, may I, sorry,
Again, that's it.
No, lordships may keep it on the date your lordships were initially giving. He's saying he'll cancel his.
Yes.
Because my lords, the problem is, he says I'm answerable to my clients for, yes.
Then which date is convenient? 12th.
Whatever date your lordship.
12th is all right?
12th.
The earliest date convenient.
12th, my lords. My lord, just now that was by 12th was fine.
12th, if it's all right, then we'll do it on 12th.
Yes,
12th.
great.
12th. November.
Great.
That's the first matter.
The lordships.
The remaining matters will come tomorrow. There's one matter, I think, some adjournment matters are there.
I dare say it will be shown as a part of.
Adjournment matters, item 103. Lord Counsel for the petitioner seeks an adjournment by way of a letter on the ground of ill health based on 8th January, not 8th, sorry, that's the first week, so 22nd January. Then one more item is there, 106. Lord Counsel for the petitioner seeks an adjournment to enable him to file a convenience compilation. That is also on, sorry? But once you ask for an adjournment, leave the date to us. 29th January. 29th January. Once you miss the bus, you go to the back of the queue. Any other matter? That's all? Oh, there's one more. 117, Learned Counsel for the respondent seeks an adjournment to enable him to file translated copies of the depositions of the defense witnesses.
It took time.
Based on, oh, I'm looking at the wrong calendar. Look at
My lords.
106.
it is 28th January,
Jan.
21st January, 21st January. And this one will go to 4th February.
My lords, our only difficulty is 106. I'm appearing for the respondent. They have an interim order in their favor.
106. 106 has gone to?
29 January.
My lords, we have a status quo against us operating in the matter.
We thought we would not be able to file it, but we managed to file it last night. Therefore, if my lord should take it up.
That's the convenience compilation matter, is it?
We've also served it on the other side.
3rd December.
3rd December. Grateful, my lords.
That's all then?
Lord, your lordship, item 107, my friend and I are having a
joint request, there is a batch of 29 appeals under the income tax. That we need to file a convenience compilation. There are several provisions. My lords, may kindly accommodate for a period of 3 weeks, my lord. Will. But in that item 105, my lord, has nothing to do with this batch.
Which one?
In that item 107.5, as
Yes.
my lord, it is to be D-tagged, my lord, it is nothing to do with the insurance cases.
Oh. This
Rest of all-
CIT4 though.
My lord?
It's shown as CIT4 Kolkata versus
Kanoria, that has nothing to do with the insurance, my lord. All others are insurance cases.
This has to be
That has
D-tagged.
nothing to do.
Oh, you're
It's
not-
not there, but that's not the issue there. my lord.
This is
That
D-
is to be
to be
deleted.
D-tagged.
Rest of the matters, my lord, I request some time.
Then, item 107, Learned ASG appearing for the income tax authorities seek some time to file convenience compilation based on 28th, sorry, not 28th, and all are going to 28th only, 21st January. We are informed that CA number 13772 of 2015, which has been clubbed with this batch of cases, is not connected thereto. Registry is directed to detag this matter and list it separately on 28.
Obliged.